We are ready to go.
Excellent. Welcome everyone to the Judicial Proceedings Committee. Today is Thursday, February 25th, 2021. We have 8 bills on the docket. We'll start off with Senator Reedy, but I'll read the list first, then I'll kick it over to you, Senator. First, we'll start off with Senate Bill 559. We'll then go to Senate Bill 280, 643, 527, 623, 629, 671, 690. So with that, we'll start off with Senator Reedy with Senate Bill 559. Senator Reedy, good to see you.
Hi, good to see you all again. Glad to be back before you to present Senate Bill 559, and I hope we can consider this bill a little bit of housekeeping. That we passed this bill unanimously through the Senate last year, and then of course, like a lot of things, we ran out of time on the House side with the early adjournment. And this is I feel a very common sense, really a clarification in the law. Senate Bill 559 would correct some confusion about allowing a police officer to obtain a warrant for a blood sample. Currently, the law authorizes police officers, if they have reasonable belief that drugs were a factor in an accident, to take a blood draw only in cases involving fatalities or life-threatening injuries. For other cases that don't fall into this category, the law is currently being interpreted by some as a prohibition on getting a search warrant for any kind of blood draw, and it seems to be some confusion in some of the courts. And so in order to, what we always seek to do in this bill is just to add a very simple statement that says, or as required by a valid warrant. And in order to allow law officers to effectively deal with impaired drivers that don't fall into the category of death, Senate Bill 559 would just permit an officer to make that determination and go seek a warrant from a judge. And it would make it clear that that warrant is valid to execute for the blood draw once they have the warrant. I have several witnesses with me today that can speak more specifically to some of the issues surrounding the issues on the judicial side, and so I'd be happy to turn it over to them, Mr. Chairman, or if there are any questions.
Excellent. Thank you, Senator Reedy. And I have your primary witness is Mr. Daggett. So Mr. Daggett, you'll have 5 minutes. The floor is yours.
Mr. Chair, members of the committee, thank you very much. I won't take 5 minutes. My name is David Daggett. I'm a member of the Maryland States Attorneys Association. I've been a prosecutor now for getting on 30 years. I'd like to thank Senator Reedy for sponsoring this bill again this year, and appreciate his knowledge of the issues. I want to begin by reiterating or making it clear that in order, as most of you know, in order to get a search warrant, the police officer in applying for the search warrant has to have probable cause that the person is impaired, that drugs or alcohol are involved. You just can't, a search warrant can't be used as a fishing expedition. So to allay everyone's fears, you don't have to worry about, or it's not a situation where police officers can just go, okay, well, we want to get a warrant. We don't know what's going on with this guy, so we'll get a warrant. You have to establish probable cause, in fact, that the person is impaired either by alcohol or drugs. Otherwise, a judge can't sign it. And as Senator Reedy said, there's a slight confusion. I put it in my written testimony. I think I kind of laid it out, but it's very important because of that slight confusion in the language. Right now, it says the language in both the traffic code and the courts and judicial proceedings articles say that except in cases involving a fatality or a life-threatening injury, a person may not be compelled to take a test. And some members of the judiciary have determined that that language, may not be compelled, means that you cannot get a search warrant. Well, Maryland is, there are very few states in the country that do not allow search warrants for misdemeanors. And this, with the way this law is being interpreted right now, that kind of goes along with that, saying, well, it's a DUI, it's a misdemeanor, and therefore you can't get a warrant. And that's not what the statute says. The Attorney General's office has issued a 20-page 20-page memorandum in which they talked about the law itself, which I would be, if the committee's interested, I'd be more than happy to make that available. It goes and they understand, and in the opinion, they believe that that search warrants are legitimate and are valid and can be issued for DUIs, these types of things. They understand that the language is somewhat confusing, but they go through all the different states and that do allow it. And I think it's a pretty well-written opinion. It is quite long, actually. The Supreme Court of the United States has said that in a number of recent court opinions that officers have to get a warrant. They have to apply for a warrant when they want to draw blood. But yet we're being told by some that we're not allowed to. So we're kind of, prosecutors and police are stuck in a situation in which we have probable cause. We try to get a warrant, but we're told that maybe we can't do that. As the committee probably knows, the impaired driving, especially drug impaired driving, is really taken off. There's a lot of it's really gone up across the country over the last few years. There's a lot more drug use and a lot more impaired driving. In a typical DUI case, 1 out of 3 people refuse to take a breath test. They just won't do it. But in a drug case, in a case in which drugs are believed to be the impairing factor, the refusal rate is over 50%. So police officers are offering blood tests for people suspected of being impaired by controlled dangerous substances. And in over 50% of the cases, they're refusing to do that. And it's very difficult to get convictions for impaired driving by drugs when there is no blood test or blood result. In wrapping up, I just want to point out that the traffic code and the courts and judicial proceedings article on a number of different places say that the laws, those particular laws, are designed for the protection of the public, not for the benefit of or protecting the driver. They're designed for the protection of the public. And the way this particular statute is being interpreted by some, it's protecting the impaired drivers, not the public in general. Again, in closing, probable cause is required. There has to be proof that the person is impaired before a warrant can be issued. And the State's Attorney Association would strongly hope that this committee will pass, and will have a favorable opinion or report on House Bill 559. Thank you very much.
Excellent. Thank you, Mr. Daggett. And next up, we'll have Mr. Coyne.
Thank you, Mr. Chairman. Good morning, ladies and gentlemen of the committee. Thank you for having me. Thank you for Senator Reedy for sponsoring this bill. The Carroll County State's Attorney's Office is in support of this bill. I'm one of the deputy state's attorneys, and I concur with Mr. Daggett and his testimony, and just clarify and add to that the Fourth Amendment to the United States Constitution prefers warrants, both by case law and by the words of the amendment. They prefer warrants, but there are some recognized exceptions like consent, and in this case, implied consent for the Maryland drunk driving laws. The statutes, both in transportation article and the courts article, allow implied consent to allow people to consent to take either a breath test or a blood test. However, if they don't give consent, the officer should be allowed to go ask a neutral, detached judge for permission, provided there's probable cause, to get a warrant to compel that blood draw, to get evidence which could be inculpatory, meaning that they're impaired by drugs or alcohol, or exculpatory. It's objective evidence, scientific evidence from that blood of the blood alcohol content or drug content of a blood. And again, this bill would clarify some confusion. I think the chief judge of the district court was of the opinion that the language of the existing law didn't allow for officers to get a warrant, because that judge read it as a very narrow reading, as opposed to what the Attorney General and some of us read it. Again, this is just to clarify that, yes, warrants are the preferred method, and yes, officers can go get a warrant from a judge who's a neutral third party. Not just judging on their own decision on probable cause, but a judge would be the one to sign off on it to make sure that the citizens' rights are protected and that evidence can be gained by the use of this warrant. So I would urge this committee to give Senate Bill 559 a favorable review, and I'm happy to answer any questions. Thank you.
Thank you very much. All right, next we'll have Ms. Axel, there you are.
Thank you, Chairman Smith, and distinguished members of the committee. Thank you for your longtime leadership on the impaired driving prevention issue and the opportunity to testify before you today in support of Senate Bill 559. I am Brandy Axtell. I'm the Senior Vice President of Responsibility Initiatives at responsibility.org. This bill is really important to preventing impaired driving overall, but especially in the ability to detect drug-impaired driving and also drivers who are impaired by multiple substances. We work in all states, even though we're headquartered in the Virginia, DC, Maryland area. We work in all states. And what we have seen is as states are legalizing cannabis and expanding their drug testing as a necessary part of that process, it's especially important to enable law enforcement to utilize search warrants to secure blood evidence in these cases. Currently, DUI is really the only crime where the investigation stops after the minimal evidence is obtained, and that's due to standard operating procedure. If a law enforcement officer observes impairment and detects a BAC level above the legal limit of 0.08, the investigation typically ends there. And that makes it really difficult to comprehensively and effectively address offenders' drug-impaired driving problems, and it sets up a scenario for repeat impaired drivers. I know that the committee heard testimony from people on Noah's Law. Noah Leata was killed by a repeat impaired driver who was using a variety of substances that night. Multiple substance impaired driving greatly increases the crash risk. And this is one of the pieces of legislation that will set Maryland up for success in dealing with that issue. If drug use is not identified, it can't be monitored or treated, and the issue remains significantly underreported and unaddressed. It's only sought the search warrant as a last resort and after other evidence has been gathered to support probable cause for an impaired driving case. When DUI cases involve drugs, time delays are significant in gathering that blood draw, and that's the most compelling evidence needed for the court. It dissipates very quickly. In fact, for instance, cannabis, if you smoke cannabis, it is going to exit a person's system much more quickly than the impairment will. And so unlike BAC tests, which align with impairment, the drug impairment does not align with the nanogram levels. And so that's just one for instance. So I really want to, on behalf of responsibility.org, urge you to pass this legislation this year. What we are seeing is that the impaired driving issue is evolving quickly. And it's really evolving to a place of multiple substance impaired driving. David Daggett's peer in Colorado addressed a group of traffic safety experts recently and said, my average DUI has 3 to 5 substances on board. That is what we're seeing in many states, and this bill is an important part of setting Maryland up for success as the impaired driving issue evolves. Thank you, and I urge your passage.
Excellent. Thank you very much. And with that, that'll conclude the testimony for Senate Bill 559, and I'll turn to the committee for questions. Seeing none, that'll conclude the hearing for Senate Bill 559. Senator Reedy, and to your panel, thank you very much. Have a good afternoon. Have a good one. All right, next, I see Senator Feldman is here, so we'll switch over to Senate Bill 280. Senator Feldman, the floor is yours.
Thank you, Mr. Chairman. So just quickly, by way of some background, the Washington Metropolitan Area Transit Authority, WMATA is what we call it, and also known as the DC Metro System, was established about 40 years ago, in 1967, through an interstate compact that is Maryland, the District of Columbia, and Virginia. And so any changes we want to make to that compact has to be signed off by all 3 jurisdictions. You may recall just a couple of years ago, Delegate Corman and I had a pretty significant build-in with Metro funding, and we needed to have Virginia, Maryland, and DC all pass identical legislation to change and amend this 3 jurisdiction compact. And so in 1976, Congress authorized the establishment of something called the Metro Transit Police Department. And the MTPD is responsible for law enforcement, public safety, transit facilities throughout the DC metro area. It actually has 400, it's not a small police force, it's got 490 police officers and 64 security special police under its jurisdiction. And obviously this committee knows all too well, and you guys have been in the eye of the storm in terms of the national topic of police reform and the desire to create more transparency and accountability for law enforcement. But because of the unique nature of this, again, 3-jurisdiction compact, there's actually no single external oversight body for the MTPD, be it government or civilian. Nothing exists like you would have for state or local government or an agency. So this issue actually was highlighted about 1.5 years ago at public hearings held at the end of 2019 in the District of Columbia by DC City Council Robert White, and you'll see his testimony. He's submitted written testimony. He couldn't be here today. He sent his chief of staff to weigh in. He did testify on the House side, but the fact is, in that case, he held these hearings as a result of some very high profile incidents involving excessive force, as well as accounts of a system that was in place here, whereby officers were actually rewarded based on how many arrests were made, which in turn gave rise to sort of legislation introduced in the District of Columbia in December, similar to Senate Bill 280. So this bill is very similar to what's already passed in the District of Columbia by Councilman White. And I'd also note the cross-file on this bill is Delegate Eric Barron. It's House Bill 666. So Senate Bill 280 does 2 things, very specifically 2 things. It establishes for the first time an 8-member civilian complaints board as an oversight mechanism for the Metro Transit Police. So 2 members will be from Maryland, 2 from the District of Columbia, 2 from the Commonwealth of Virginia, and 2 from the federal government, a total of 8. And you can look at the bill, you'll see the powers that are laid out in the bill. It empowers this panel to receive complaints, investigate alleged abuse of police powers, disciplinary authority, and the ability to refer action elsewhere. And then there's an annual reporting requirement of their activities to report to the WMATA board. The amendments in the bill conform it to the House bill, Delegate Barron's bill. And I will say, in the interest of full disclosure, again, this bill would now have to be passed in the Commonwealth of Virginia and the Virginia General Assembly. And as of right now, they have not moved on this bill. So I want to just put that out there. We have DC has weighed in. We've got this bill. Virginia is still in session. So we'll have to see and wait to see what happens there. Again, Councilman White's not here, but he did send his deputy committee director, Curtis Sori, who's here to testify in support of the bill and answer, I think, any questions. They again had high profile hearings in the district. One final note, Mr. Chair, the opposition, I know we have testimony written for Mr. Doherty, who is the head of the Metro Transit Police Labor Union, and I think he may weigh in. And he doesn't have any opposition to the provisions, I think, of the bill prohibiting the use of quotas and quantitative metrics to, and that whole issue, I think, has basically been dealt with already. That is in the bill. I don't think he has any problem with that. That practice of incentivizing folks to actually make more arrests and you get, more pay or something like that. I think that's in the bill. I don't think he's opposed to the bill on that front. The only opposition that he does, he is opposed to the bill and the establishment of this new civilian panel, 8-member panel or board, oversight board. And I think the basic argument, as I read his testimony right now, is that there is now in place an internal review panel that was established after the DC bill was introduced. And I think he would argue that that panel has not been given enough time to do its job. But as Councilman White notes in his testimony, although that panel is positive note, it's actually not empowered to do much. So for example, it's not authorized to receive complaints from the public or engage with officers about their experiences in the department. and can only receive complaints and cases on a quarterly basis, in many cases after the cases have already been closed. And it can only provide recommendations to the police chief for future cases, which the chief can ignore. So for all those reasons, not exactly a robust external oversight body that is contemplated with this bill and this new board that we're putting in place. So Mr. Chairman and members of the committee, again, this Metro Transit Police Department is actually one of the largest police forces in the entire DC region, and they interact with our constituents on a daily basis, and yet we have, again, no external oversight body in place. It's a huge gap. That's what this bill seeks to correct. And with that, I'd ask for a favorable report on Senate Bill 280 with the amendments that conform the bill to the Barron bill over in the House.
Excellent. Thank you, Senator Feldman. And thank you for bringing this before us. You have your primary witness is Ms. Suri from Councilmember White's office. So Ms. Suri, you'll have 5 minutes as the primary panelist. And please tell the council member I said hello.
Absolutely.
I'm going to hand it off to Senator Hedelman. She'll be chairing the rest of the proceedings this afternoon for a few minutes here. But thank you very much. The floor is yours.
Good afternoon, Chairperson Smith and members of the Maryland General Assembly Senate Judicial Proceedings Committee. I'm Kirti Suri, Deputy Committee Director of the Committee on Government Operations and Facilities, chaired by Robert White, Council Member at Large for the District of Columbia. I'm honored to testify on Councilmember White's behalf today on Senate Bill 280, the Washington Metropolitan Area Transit Authority, Metro Transit Police Quotas, and Metro Transit Police Complaint Board. Councilmember White is currently chairing our own committee hearing, but wishes he could be here today with you. The Washington Metropolitan Area Transit Authority, or WMATA, compact is an agreement between the District of Columbia, Maryland, Virginia, and Congress that created the second largest public transportation system in the nation. The bill before you today would amend this interstate compact to create a civilian complaint board comprised of residents from the District of Columbia, Maryland, and Virginia, tasked with oversight over the Metro Transit Police Department, or MTPD, the multi-jurisdictional law enforcement agency that polices Metrobus and Metro Rail trains and stations. Councilmember White had the privilege of chairing the committee with oversight over WMATA in the District of Columbia in 2019 and 2020. During that time, after several incidents of excessive police brutality by MTPD, he introduced the companion legislation to the bill before you today in the District of Columbia legislature to initiate the process of amending the compact. To effectuate an amendment to the compact, all 3 signatory jurisdictions legislatures must approve the same amendment, and Congress must consent. The District of Columbia approved this amendment to the compact on December 15, 2020. I strongly encourage you to do the same. The District, Maryland, and Virginia must act together to eliminate a gap in which MTPD, one of the largest police departments in the tri-state area, has no external oversight, be it government or civilian, given its unique creation under a regional compact. MTPD plays a vital role in ensuring safe passage by residents of all our jurisdictions on Metro Rail and Metro buses. However, multiple incidents occurring over the past few years have highlighted how problematic policing practices on Metro can often make riders, especially people of color, including children, less safe while riding Metro. Meaningful accountability to any single oversight body is absent for MTPD, with that responsibility spread across 3 jurisdictions and Congress. Our committee held a public oversight hearing with MTPD in November 2019, in which several incidents were discussed where MTPD officers used force against riders, including one incident from summer of 2019 when a teenage African-American boy was pinned to a Metro Rail platform floor by MTPD officers, and a bystander who attempted to de-escalate the situation was tasered so excessively that he suffered severe and permanent injury. The bystander was a graduate student working on Wall Street. Today, his education and career have ended due to his injuries. The young boy suffered significant mental health injuries following the event and became a victim of homicide a year later. Other recent incidents include a 21-year-old woman having her front teeth broken and suffering a fractured knee in front of her young kids for suspected fare evasion. In response, the residents of the Greater Washington region and organizations like the Washington Lawyers Committee for Civil Rights and Urban Affairs and the National Action Network called for more transparency and oversight. They asked for WMATA to publicly post MTPD data, including stop, search, arrest, and use of force reports, something that DC Metropolitan Police Department and many other police departments around the country have already provided the public with. Our committee has also heard from current and retired MTPD police officers about the concerning culture within the department, including racist and sexist attitudes and employee disciplinary and promotion practices. One officer anonymously shared evidence of a contest advertised in MTPD offices, rewarding officers for engaging in enforcement actions with greater points for more severe actions like arresting rioters. While that practice has since been stopped, MTPD continues to evaluate officers by quotas on aggressive policing tactics like arrests and tickets. This ensures a heightened level of tension as opposed to de-escalation and conflict resolution. We took the feedback received and introduced this legislation with the hope that a civilian oversight body empowered to investigate police actions and remedy complaints will provide the public with a renewed sense of confidence in MTPD. After the bill before you was introduced in the District of Columbia, the WMATA Board of Directors approved the creation of an internal investigations review panel. While the panel is a positive step, it is very different from what the bill proposes. The panel cannot receive complaints from the public. Chairman, may I finish for another 30 seconds?
Go ahead. If you could wrap up, please, that would be great. Thank you.
Thank you. I just want to point out the differences between what this bill proposes and the investigations review panel. And the panel cannot receive complaints from the public or engage with officers about their experiences in the department. It can only review MTPD cases quarterly after they are closed and can only provide recommendations to the police chief for future cases. The chief of MTPD is not required to implement those recommendations, and the panel cannot require corrective actions or drive changes in data transparency. Law enforcement agencies across the country are moving in the direction of civilian oversight. It's important that the civilian oversight is not hostile, to note that civilian oversight is not hostile to law enforcement, but rather complementary to it. Our residents and visitors are users of the WMATA system. As their representatives, it is important that we ensure proper oversight and responsiveness. MTPD is one of the largest police forces in the entire Washington metropolitan area with 645 employees, and none of us have jurisdiction over them that allow us to assist a resident or a tourist in need like we would with our own local and state law enforcement agencies. We owe it to those impacted by excessive force and their families and to the MTPD officers who blew the whistle on disciplinary practices in their department, and to communities that have been advocating and protesting for police reform. To take this opportunity to fill a much needed gap in oversight over police department interacting with our residents daily as they navigate the region by public transit. I want to thank Senator Brian Feldman for introducing this important bill. With its passage in the Maryland General Assembly, our region will be one step closer to achieving this reform. Thank you.
Thank you so much, Ms. Suri. I think that's it for the favorable. We have signed up for unfavorable, Mr. Colin Doherty.
Thank you, ma'am, and thank you, Madam Chairman. Thank you, ladies and gentlemen. I want to open by thanking everyone for their time here today. My name is Colin Doherty. I'm a detective with the Metro Transit Police Department, and I'm here today as chairman of our union, DC Lodge 1 of the Fraternal Order of the Police, and on behalf of the FOP Maryland State Lodge. I'm here today to speak in opposition to Senate Bill 280. I certainly understand that it's not expedient to oppose legislation in favor of more police oversight today, and I want to ensure you that our union members do not oppose greater police oversight in general. Indeed, shortly after George Floyd was murdered last year, this union recognized the need for reform locally and nationally, and we put that recognition into action by submitting a mission statement to Paul Wiedefeld, Metro's general manager, imploring him to partner with us and taking immediate steps towards reforming our agency by providing more accountability and improving our relationship with the communities wherein we serve. Specifically, we demanded that the department stop evaluating officers using quantitative metrics and other standards that serve primarily to promote unnecessary stops and arrests. We demanded that MTPD leadership embrace stronger ethical standards of policing and begin a peer support program. Since then, management and the union have actively engaged in writing general orders and implementing some of these positive changes as quickly as we can. Additionally, we demanded that the MTPD leadership foster stronger bonds of diversity within the department and make immediate efforts to recruit, retain, and promote officers of color across the board. We demanded that efforts be made to do away with the stop and frisk culture that, however well-intentioned in the name of crime reduction, serves primarily to cause issues in communities who suffer disparate interference from those steps. Finally, we demanded that the department find and implement a nationally recognized de-escalation training program that all officers are trained on and that the community is invited to participate in. Happy to report that department leadership in WMATA immediately partnered with the union and formed 5 committees in pursuit of these points, each of which are actively engaged in the various aforementioned reform measures. As you can see, we're already actively engaged in halting the use of numbers to evaluate police, and we find ourselves wholly in agreement with the originators of this bill concerning that principle. Brings me to my next point concerning our opposition to the proposed Metro Transit Police Complaints Board. I'll draw your attention again to the recently constituted MTPD Investigations Review Panel that WMATA took the initiative to form. The panel has barely had an opportunity to function, and yet here we find ourselves with another board of oversight ready to stand in competition to that board. Should the Metro Transit Police Complaints Board be constituted by this legislature, the MTPD would find itself the only police agency in the state to have such a board overseeing it, to my knowledge. Our officers are willing to be the vanguard of modern and reform policing, but I believe that oversight of this agency should be in line with the oversight provided for other police agencies within our jurisdictions. And also, I'll challenge this body or any investigatory body to find evidence of systemic failure to investigate and act upon complaints against our officers.
Time.
All right, ma'am, I just want to close by saying I thank everyone for their time, and I'm confident that our officers do face the consequences of their actions. As a community member, I want the same highly trained and professional cops working our neighborhoods and streets that you want. I know that the officers of the Metro Transit Police feel the same. On behalf of our union, I urge you to return an unfavorable report on this bill and continue working with us on those reform measures underway already. And I thank this body for their time.
Thank you very much, Mr. Doherty. Are there
Yes,
any
ma'am.
questions from the committee? Senator Casserly.
I guess my first question would be for Senator Feldman. There was a couple of times references that the board could only consider complaints quarterly or something quarterly. I'm not finding that in the bill. Where is that? He's muted. Thank you.
Yeah, and Ms. Suri might want to, you're talking about the new board that Mr. Doherty was referring to, this internal, we were trying
The one established under this bill.
Well, no, the point I was making is Councilman White makes, no, this particular board would have the ability to investigate complaints, receive complaints all the time. What I was referring to is Mr. Doherty referenced an internal panel that's just been created. He was saying that we don't need this bill because we have a new internal panel that's been created and they haven't been given enough time. And I was pointing out that panel only takes complaints on a quarterly basis. And so it's not exactly the robust oversight.
I got you.
So that was the point there. Yeah.
So if I can then, looking at the bill, so we set up this new police complaints board and it's a total of, I think, 8 civilians.
Right. So it's 2 from Virginia, 2 from DC, 2 from Maryland, and 2 from the United States Congress gets to put 2 people on.
There's no requirements for them, and that we don't say you have to know something about policing or have a law degree or anything. It's just 8 people, right?
Well, look, I mean, that would be also true. The WMATA Board of Directors, of which Maryland has 2 representatives, of which one is our, the governor, I would assume, I would hope that the respective jurisdictions would appoint folks that have relevant background. I mean, that we could say that about a lot of things, Senator, but yes, we're giving the state of Maryland an opportunity to put 2 people on there. And I would assume and hope again that we wouldn't just waste 2 picks without putting people who had no relevant background on them. But again, that argument could apply to our WMATA board of directors and any number of other boards, commissions, et cetera. I have confidence we would pick people that had relevant backgrounds.
Well, I would imagine that for the WMATA board, we pick people who know something about Metro transport, right? I mean,
we could look. As I say, this bill is mirrored after the bill that's already passed DC. you know, I can't, I don't have a better answer other than we get 2 picks on the board of 8, and
Gotcha.
my hope is,
And those,
you're right,
so
it doesn't
those,
specify in its language that you should put people on this board that have relevant, it does not say
Right.
that in the statute. I would agree.
okay, so this board, these 8 civilians of whatever backgrounds people want to pick, they meet at least monthly and they adopt their own rules. And then they receive all complaints regarding the complaints of harassment, use of force, language, discrimination, retaliation, etc., that are made against any of the officers covered by this compact, right?
Right, assuming Virginia passes the similar bill. Don't forget,
Gotcha.
even if we do this, this won't become law or an amendment to the compact unless Virginia follows suit, just to be clear.
Yeah.
Right.
So these civilians, these 8 civilians, whatever background, they receive all these complaints, and then they they would get those from the various police agencies, and then this civilian board, they can investigate and adjudicate each of these matters, right?
And if Miss Surrey, because she was involved in the DC, and if we could unmute her, she may be able to.
That's fine. I can address the questions to her if you'd prefer. Yeah. That's fine. Can we just?
Well, yeah. I mean, again, if she has something to add a little bit, I think the bill speaks for itself, so I can't really add beyond.
I'm just trying to review. I mean, look, it's a 6-page bill, almost all new language. So I'm just trying to make sure I understand it. So I'm sort of restating
Sure.
so I understand the process here, and I don't want to miss anybody. But we have these 8 civilians, all the complaints against Metro. It only covers Metro Police, right?
Correct. It
Right.
would only cover Metro Transit Police.
Okay. So
We
all the
modeled
complaints
yes, we modeled the formation of the
No,
board
that's okay. I don't know who
after.
you modeled it for. That's okay. I'm really not. I was trying to understand the process here, and so
Sure.
if we could, thanks. So we these 8 civilians, they get it all. Then all the complaints against police in any of these matters I described, they come before these 8 civilians, and those civilians, they're going to investigate them and they're going to adjudicate them. Correct?
Correct.
And there's no set process or training or standards by which they either investigate or adjudicate these complaints against these police officers, correct?
The board would create those standards.
They
correct.
create their own. These 8 civilians of no particular background or training, they're going to create these policies, procedures, rules, whatever, by which they're going to investigate and adjudicate the guilt or innocence of these police officers, correct?
They're not adjudicating guilt or innocence. They're adjudicating whether measures need to be taken or corrective action needs to be taken with regard to police action or policies.
Let's be specific. Then I'll read from the bill. Tell me if this is wrong. It says that the complaint board, after they get a complaint, if the complaint, so they're going to appoint an examiner, right? These 8 civilians appoint somebody to examine, to basically as a hearing officer, right?
Well, they would examine the situation, and if they feel that there needs to be further investigation, they would refer it to the relevant prosecutorial body within each state, depending on where the incident occurred.
Well, actually, I think you're jumping ahead of yourself here, because the complaint board, I'm looking on page 5, section 17 of the bill, and that says that this complaint, these civilians are going to, they'll assign it to an examiner, who I assume would be one of them or anybody they pick, right? And this examiner doesn't have to have any particular training, knowledge, experience, etc. None of that's provided in the bill. So this person is going to investigate it, and then they're going to, that person is going to make findings of fact. And then if the complaint examiner determines that any of the allegations are sustained, then the board is going to transmit the entire complaint file to the complaint examiner and to the Metro Transit Police for appropriate action. But the complaint examiner, the hearing, the findings, the factual findings and conclusion of a violation by these 8 civilians, that's binding. That goes back to the police, the police commanders for appropriate discipline based upon the findings made by these 8 civilians, right?
Correct.
Right. So basically what happens, I'm trying to just compare and contrast to what we would normally do to any other civilian we got folks working, I'm sitting in Annapolis, we got all these people who work for us, and they're civil servants. They're not carrying guns or anything, but if they are accused of a wrongdoing, ultimately they would have, if they didn't accept punishment by 4 different other levels or 3 different other levels, they would have the right to go before a hearing before the Maryland Office of Administrative Hearings. And that hearing would be by somebody who had attended law school, graduated from law school, passed the bar exam, been through a background check, and was then certified to practice law, and who probably had practiced law for some period of time, usually 5 or 10 years. And they would conduct a hearing in accordance with the Maryland Rules of Evidence and Procedures, which are about this thick. And they would then make findings of fact based upon all of that. And they would be bound by rules of evidence, et cetera. But we're going to do different for the cops, for these we're going to dispense with all that formality and all that. And we're just going to let 8 civilians of no particular background, training, or experience come up and make up their own rules and procedures and policies and decide whether a cop, based upon their own little, whatever due process,
Senator, could I just
they're going to find them
suggest one-
guilty. And then that finding of guilt is going to be binding upon the policeman, the police agency who's got to render punishment based upon their findings. Tell me it's not what we're doing here.
Well, can I just suggest one thing you might want to consider? I don't think it would violate the compact with respect to the 2 members from Maryland in particular. You could probably amend the bill to make sure that those folks have certain backgrounds criteria. I don't think that would violate. We did this 2 years ago. Our bill wasn't like verbatim. There are some modifications you could make to this bill, and I don't think it would violate the compact.
And I appreciate the Senator, but then I've got 2 out of 8 people making the decisions here. I've got 1/4 of the decision making is now under our standards, but the other 3/4 is under whatever standards the other members of the compact, if any, decide to make. So it's just troubling. I've always
May I respond?
on the WMATA. I have no problem. I appreciate your leadership on WMATA, Senator Feldman. You've been you've been right there, proactive, and I have appreciated where you've come at on that. You've done a lot of great stuff. So please don't misunderstand.
No, look, you're racist.
And I know you didn't write this bill. This is a compact. I know this. You didn't put this language
May
in
I
here.
say
So-
that this is we're inserting a civilian complaint board.
Go ahead, Ms. Surrey. Sorry.
We're instituting this civilian complaint board in the absence of any kind of external oversight over this Metro Transit Police Department. And this is not a unique format. Many jurisdictions, including the district ourselves, we have a civilian complaint oversight board with almost identical responsibilities, and it functions fine in the district. We're happy to send you more information about that, but we modeled it after that, and it does function in the district. So it's not like it's a foreign concept or that we've come up with it, without any kind of basis in reality in other jurisdictions as well.
Yeah, that's debatable, but thank you. I mean, that's a value question or value judgment you just made about your own police, but I'm not sure I support that one. But anyway, thank you. I appreciate it. You've answered my questions.
Are there any other questions from any other committee members? All right. Thank you very much, Senator Feldman.
Thank you, Madam Chair. Thank you, JPR.
Thank you.
Thank you for having me.
Thank you, Ms. Surrey. We'll turn now to Senate Bill 643, Senator Huff.
Well, thank you very much, members of the committee. This is a pretty simple bill. If you look at page 2 of the bill, what it does is it seeks to redefine the term absconding to include leaves a treatment facility that an individual was placed in under the 8507 of the Health General article for drug or alcohol treatment. And the reason that this is necessary is that when we did the justice reinvestment, and actually this was one of my big parts, was the technical violations, that we defined a technical violation as, and this was for deciding if someone should, if they were out on parole, for example, or probation, and you did not want the person to go back to prison and serve their whole time. So we created these technical violations to say, hey, look, they missed one appointment with their probation officer, or they had, it means a violation of a condition of probation, parole, or mandatory sentences that does not include an arrest, So it's a new crime. Violation of criminal prohibition other than minor traffic violation, a violation of a no contact or stay away, and 4 was absconding. So unfortunately, what happened though is that absconding does not include that if somebody is, as part of their probation, agrees to go to an 8507 bed and they simply leave the treatment facility. So the whole idea of the justice reinvestment, one of the points was to get people into treatment. Well, obviously we've got a problem if we send them to the treatment facility, they just straight up leave, then they have, in my opinion, that's absconding. But what the Maryland Court of Special Appeals said, and correctly so based off our law, and you've got the judiciaries in here today too to testify, that under the way that the technical violations are written and absconding is defined, that, well, as long as they still contacted their probation officer, they're all set, they're all good, they're not absconding. Well, obviously we know the whole policy point of this was to take people from prison, get them into treatment. But if we have a system now that's set up where we send them to treatment and they can straight leave, abscond, not take part of the program, it's defeating the whole purpose of the program. And so with that, I'll hand it over. I know we got state's attorneys, we've got folks from the judiciary here that give more background as well.
Senator Huff, are we ready to turn to your panel?
Yep, I'm all set.
Okay, I have I have State's Attorney Schellenberger. He's your primary witness? Okay.
He's raising his hand, so I say yes.
Senator Hellman, thank you so much. Senator Huff, good call on pulling this one in. Scott Schellenberger, Baltimore County State's Attorney, in support of Senate Bill 643. So what we did when we did justice reinvestment, and I worked closely with Senator Huff and several other of you on this bill, was we were trying to limit the amount of time somebody could get for having small violations of probation. And that was the whole basis, because the research showed that short sentences for what we call technical violations were the best way to get a probationer's attention without doing further damage to, say, their jobs or their home life or any other aspect of their life. So for a first violation on a technical violation, you can only get 15 days. Now, we came up with exceptions to that, and the exceptions, as Senator Huff indicated, are an arrest or a summons has been issued, a violation of a criminal prohibition other than a minor traffic offense, a violation of a stay away order, or absconding. So we interpreted that to mean walking off from your probation completely. In the same bill, Justice Reinvestment, we greatly expanded drug treatment. That is inpatient drug treatment. You're in Baltimore County Detention Center, you're in the Division of Correction. You say to the judge, all my problems are because I have a drug problem, send me to treatment. So they go to treatment, and the way the law is written now, and we have now a Court of Special Appeals opinion, you walk away from drug treatment, the only thing the judge can do to you is give you 15 days. And please, this is not an attempt to overly punish anyone. This is an attempt to get them back into drug treatment by holding more time over their heads. Because what we have found has happened is they beg to go to drug treatment, the judge grants the order, they walk into drug treatment, and then they walk out because they know the worst thing that can happen. They go serve 15 days standing on their head, and now it's all over. And we've lost the ability to incentivize them to get the drug treatment that they need, and that we, frankly, in this day and age, we want to save their lives by getting them off of these drugs. Because we've talked all this session about fentanyl and the terrible damage that it has done in our community. So what we want to say is, if you walk away from drug treatment, it is absconding. It's the same as if you've completely ignored your probation officer and not done anything. And what that allowed the judge to do is craft a sentence that could also include more drug treatment, better drug treatment, or more importantly, it disincentivizes the person from walking away from treatment, because now they know, thank you, they now know that sentence could be much more than 15 days. We think this is a very sensible bill. We urge a favorable report. Thank you.
Thank you, Mr. Schellenberger. And I apologize. I was in error here. Mr. Riley is actually your 5-minute witness. So Mr. Riley, you get your 5 minutes.
Well, thank you, Senator Hedelman. I think State's Attorney Schellenberger covered most of what would be my testimony. I'd like to thank Senator Huff for bringing this piece of legislation that's been sponsored by the Maryland State's Attorneys Association, where I serve as the legislative chair. Just some things that we do have a philosophy now with the JRA to emphasize the away from the jail treatment bed. However, in the years following JRA becoming law, we are, as state's attorneys, seeing this trend and a pattern of incarcerated individuals being placed in treatment facilities pursuant to 8507s, and those individuals walking off from the treatment facilities. That's because we believe that there is a perverse incentive to the incarcerated individual who has been given the option of treatment. They can stay in a placement, continue the hard work of sobriety, or they can walk off and be subject to this 15-day maximum penalty. Also, keep in mind, as my colleague stated, it makes it very difficult, if not impossible, to put them back into an 8507 facility because they just have an active 15-day sentence. As you may or may not know, certainly a inpatient treatment is going to be significantly longer than that. No inmate's going to agree to that. So we think that this is a common sense application that would change the definition of absconding to what we believe was the original thought of the legislators when they brought it in, and we asked for a favorable report. Thank you.
Thank you very much, Mr. Riley. Now we will move on to Chief Judge Morrissey.
Good afternoon, Senator Hedelman, members of the committee. For the record, my name is John Morrissey, and I'm the Chief Judge of the District Court of Maryland. The judiciary supports Senate Bill 643 and thanks Senator Huff for introducing this bill. We have made some suggestions to the sponsor on the House side for a very small amendment that I'll speak to at the end. To understand why we support this bill, I ask you to start with the premise that drug courts are all problem-solving courts, practice rehabilitative justice. These specialty courts favor treatment in lieu of incarceration. In the lead up to the passage to the JRA, there were many discussions regarding exempting drug and other problem-solving courts from the Justice Reinvestment Act, as problem-solving courts use a graduated sanction before any type of serious sanction is imposed, just as is the basis for the Justice Reinvestment Act. I thought it was understood that the problem-solving courts were not subject to the JRA, but in the magic that occurs in the weekend hours before sine die, the specialty courts were left in during that time. And this has caused some issues for the problem-solving courts because they do not call their hearings technical violations. They rely on their graduated sanctions, again, just like the JRA does, but do not paper the case by detailing each sanction as a technical or non-technical violation. Please remember that these are all voluntary programs entered into by the defendant. A recent appellate cases have been mentioned has been found that after leaving the treatment facility, despite the court-ordered placement, that becomes a technical violation. In the particular Crockett case that we've mentioned so far, the individual had left 6 times. So this was the 7th time that the judge imposed a sentence greater than the first technical violation. As the foundational underpinning for the drug courts is placement for treatment, we believe that leaving such a treatment is not a technical violation, but rather is a non-technical violation. It's considered a very serious violation by the judge and the court program. These individuals have simply walked away from treatment in violation of the very purpose of drug court, and that's to get them treatment. Senate Bill 643 fixes this issue. The one suggestion that we made to the sponsor on the House side was that the definition should apply to any court-ordered placement and not just 8507 placements, because there are drug placements that aren't necessarily 8507s. I thank you all for your consideration and urge a favorable support of House Bill 643, and I'd be happy to answer any questions. Thank you.
Thank you very much, Mr. Chief Judge Morrissey. Now we'll move on to Steve Kroll.
Good afternoon, everyone. I'm Stephen Kroll, the State Attorney Coordinator for Maryland. I just want to agree with Mr. Schellenberger, Mr. Riley, and thank Chief Judge Morrissey, who took again my testimony, and also thank him for MDEC. And I ask for a favorable report also. Thank you.
Thank you. Short and sweet. Any questions from any of the members of the committee? No questions? All right. Thank you very much. That will conclude the hearing for Senate Bill 643. Thank you. Now we'll move on to Senator Lee, Senate Bill 527.
Thank you, Madam Chairwoman. This is Senate Bill 527. I think all my witnesses are here. Great, okay. This bill just merely aims to fix a technicality in our current state law that creates an unintended and really super harsh consequence at a federal level. Under the current law, PBJ is not a conviction under our state law, but it is considered a conviction under federal law. A plea acceptance of probation for judgment in Maryland may trigger the deportation of a legal permanent resident, a legal immigrant, or a non-citizen, though it is not really a finding of guilt under the feds. The bill would eliminate the need to first determine guilt or a defendant's acceptance of a nolo contendere plea before PBJ is entered, thereby correcting this undesirable consequence and protecting people from the harmful effects that a technicality in the law has created. SB 623 is just that simple fix would align Maryland with other states who have taken such action, such as Virginia and New York, that have amended their PBJ statutes. The language in this bill also passed the Senate in 2020 last year, but we have some updates in this bill. So judges may impose any punishment just as before the effective date of the bill, only in cases where the state's attorney's defense counsel and judges agree that a PBJ is a available option could the immigrant defendant plea. There are many arguments in favor of the purpose for the PBJs that opponents in this bill might like to use in the other context, but I urge them to see that this, in the context, the tool is unusable and even unethical. And I would remind everyone that might want to, I hope you won't sensationalize the impact of this bill, that the relevant crimes would be limited and apply to exclusively first-time violators, just as we afford citizens this ability to rehabilitate themselves. For these reasons, I request a favorable report on SB 527 as amended. I think you might have the amendments. I'm not sure. It just merely says, for the purposes of this paragraph, the court may make findings of fact sufficient to support a finding of guilt, and in the event of a violation of probation granted in accordance with this paragraph, enter a finding of guilt and impose a sentence. And when the court finds the facts justifying a finding of guilt, the court may enter into a probation agreement with the defendant. The defendant accepts probation in exchange for the court expressly withholding a finding of guilt. The defendant knowingly and voluntarily waives the right to trial, and unless the court makes a finding of guilt under paragraph 1 of the subsection, the right to appeal the probation agreement, but not the underlying probation. So I'd like to turn it over to my witness who will provide you more particularity on aspects of this bill. Go ahead. Gabriella, are you next? Who is next?
Yes,
Chairman.
yes, I am, Senator. Thank you.
We have Gabriella, primary witness. Go ahead, Gabriella. Good to see you. Thank you.
Thank you. Chair, Vice Chair, committee members. My name is Gabriella Carl. On behalf of the Maryland Carey Law Immigration Clinic, I urge a favorable report on SB 527, which eliminates the unintended immigration consequences of probation before judgment, or PBJ. The PBJ was designed as an alternative to a conviction, offered to worthy defendants with the hope that they will meet all of the requirements of the probation, be rehabilitated, and not reoffend. But for Maryland residents who are non-citizens, a PBJ plea, because it is a conviction under federal immigration law, can trigger detention and deportation, even for people with lawful immigration status like permanent residents. As a former public defender, I brought legal challenges to PBJs that were causing this unintended harm to my immigrant clients. Though prosecutors rarely failed to work with me when I brought these cases to their attention, my clients suffered in jail for months and even years while they waited for their cases to get through the state courts. For many of my PBJ clients, ICE detention was the first time they had ever been in jail. While my clients sat in ICE detention, they lost jobs, faced evictions, didn't see their children, family, or friends. Held in ICE detention centers in remote parts of Maryland, or worse, removed to other states, their families could not afford the trip to see them. Many of the clients I had were children, teenage kids who ended up with PBJs for dumb teenage stuff that high spirits can lead to, like hopping a fence into an apartment complex to swim in the private swimming pool. One such kid was a young Black boy from Liberia who grew up in Baltimore City. He had been in the city since he was 2 years old. He didn't learn until he was in deportation proceedings that he was not a U.S. citizen, but a legal permanent resident and therefore vulnerable to deportation. He spent his 18th year in ICE custody in Buffalo, New York, a place he had no connection to because of a Maryland PBJ. Instead of spending his first year away from home at college, he spent it in jail intended for adults. He didn't see a single member of his family or friends during that time. That boy lost over a year of his life for what the state of Maryland intended as a slap on the wrist. The only reason he's still in the U.S. today is because I won his quorum nobis case. That boy and many others are why I'm here before you today with this bill. All Marylanders should have the same opportunity to take responsibility for their mistakes without suffering lifelong consequences. This bill ensures that through an equitable solution. Add an alternative process to Maryland PBJ statute so that courts can find facts justifying a finding of guilt without requiring an admission of guilt from defendants. The amendments to this bill were developed in coalition with the Office Attorney General and other experts. We worked in coalition with state's attorneys, immigration legal experts, criminal law experts to ensure that all aspects of this new PBJ comply with Maryland constitutional and common law, were responsive to an AG advice letter, and will also work to prevent the gratuitous and unintended immigration consequences. This bill has a broad base of national and regional support. The MSBA supports this bill. State's Attorney Marilyn Mosby has submitted written testimony in support, and State's Attorney Brayboy testified in support of the amended bill at the House. Baltimore City's Mayor's Office and Prince George's County Council support this bill. National organizations, including Roundtable of Former Immigration Judges, National Immigration Project, Undocu Black Network, support this bill. The Black Caucus and the Latino Caucus also support this bill. The only opposition to this bill is from the MSAA and the Maryland Judiciary. The MSAA indicated at the House hearing and in conversation that they support the objective of this bill and will withdraw their opposition when the Attorney General issues an official favorable review of it. The Maryland Judiciary's written opposition is based on last year's bill, and we believe our amendments address all of their concerns. There is broad recognition that this bill fills an important gap in Maryland law. All other dispositions, nolo contendere, not guilty, agreed statement of facts, Alford pleas, are all ruled convictions under federal immigration law. This bill does not confer additional benefits. It is not a lighter touch. The same consequences will apply if the defendant were to violate the terms of probation. This bill does not replace current PBJ law, it adds to it. It is another tool that state's attorneys and judges can use to do justice. This bill also promotes racial justice. 99% of CARE Coalition clients with the Maryland PBJ were Black or brown. Because communities of color are over-policed, prosecuted, Black and brown people are more likely to face adverse and often severe immigration consequences as a result of low-level crimes where a PBJ is warranted. This bill will contribute to finality of judgments and also to judicial economy. Recent events have made it clear that the criminal and immigration systems have been in dire need of reform for a long time. Immigrants are still under attack from Trump policies. Numerous reports indicate that it will take years upon years to fix. Trump policies continue to result in deportations of babies and children. As recently as 2 weeks ago, a 2-month-old baby and 21 children were deported to Haiti. This assembly cannot wait for President Biden to solve a state-grown problem. And this bill is an opportunity for the General Assembly to show Marylanders that it is committed to rectifying the inequities that unfairly harm and disadvantage immigrants now, especially Black and brown immigrants, in our state's criminal justice system, which directly feeds into the immigration system.
Time.
We urge a favorable report.
Oh, she was finished. Okay.
Thank you. Thank you, Ms. Carl. We'll turn now to the next witness is, I apologize if I'm going to butcher this, but Korea Abreu Jimenez.
Thank you. It's not a problem. Chair, Vice Chair, and committee members, my name is Curia Abreu Jimenez. I'm a student attorney at Maryland Carey Law Immigration Clinic, and I urge a favorable report of Senate Bill 527. I'm here on behalf of clinic client Dorothy Stewart, who asked me to address you today because she is too traumatized to do so herself. Ms. Stewart is a lawful permanent resident from Jamaica who came to the United States at the age of 10. Today, Ms. Stewart is 60 years old, a veteran, mother, and proud Maryland resident who has lived the past 31 years of her life in fear of deportation because of a PBJ. Ms. Stewart enlisted in the U.S. Army at the age of 19 in order to bravely serve the country she thought of as her home. She served approximately 7 years, completing tours in Korea and Germany. Throughout her service, Ms. Stewart was honored with multiple medals for exceptional conduct and even selected to serve on the Prestige Honor Guard team. Ms. Stewart's military service afforded her opportunity, but caused her unspeakable pain. While enlisted, Ms. Stewart was sexually abused by soldiers. She turned to controlled substance to self-medicate the debilitating symptoms of PTSD and depression triggered by the assaults. She hit bottom when she was arrested and charged with possession with intent to distribute in 1990, an incident that occurred over 30 years ago now. Ms. Stewart got clean, has no other criminal history, and thought she could finally move on, but her PBJ has held her prisoner of her past. When Ms. Stewart applied for naturalization, she learned that her PBJ, although not a conviction under Maryland state law, was considered a conviction under federal law, and not only prevented the approval of her application, but also made her deportable. Because of her PBJ, she lived in fear of deportation, has lost job opportunities, and had to watch her mother pass away in her arms, knowing that because of her PBJ, she could not travel to fulfill her mother's dying wish, which was to have Ms. Stewart return her body to Jamaica. Ms. Stewart made one mistake in her life and is still suffering the consequences today. I provide this testimony on behalf of Ms. Stewart and the hundreds of other Maryland residents that have suffered like she has because of the PBJ. We support Bill 527 because a second chance can make all the difference. Thank you.
Thank you very much. We'll move on now to Mr. Zavin. Brian Zavin.
Good afternoon. I'm Brian Zavin. I'm the Deputy Chief Attorney of the Office of the Public Defender's Appellate Division. For the reasons expressed in my written testimony, as well as what I'd like to address today, we urge a favorable report on Senate Bill 527. So the General Assembly has long recognized that the mere fact that someone commits a criminal offense in Maryland should not, in all cases, forever result in them being branded a criminal. And one way that the General Assembly did this was by the authorization of probation before judgment, or PBJ. Prior to 1975, the code did this by making it probation without a verdict. The problem at the time was that the law didn't provide a procedure for what a court was to do in the event of a violation of probation. The General Assembly attempted to fix this by putting the the finding of guilt up front by deferring sentence unless and until there's a violation of probation. But the law was nevertheless clear that a PBJ did not count as a conviction for purposes of any collateral consequences. And that should have been the end of the story. The problem was that federal law defines conviction more broadly than state law. So as a result, a non-citizen who gets a PBJ can still be deported or suffer other immigration-related consequences. And as a result, the protections that the General Assembly has afforded to persons who get a PBJ don't apply equally to non-citizens. The bill before you offers a solution, and not just to the interaction between state and federal law, but also to the problems that plagued the PBJs prior to 1975. And what it does is it authorizes a court to find that the facts are sufficient to warrant a guilty verdict, but to delay entering that guilty verdict unless and until there's been a violation of probation. And it does this because the defendant has agreed and consented to this upfront in exchange for getting the PBJ. We believe that the bill serves a laudable purpose and that it accomplishes this in a fair and a lawful manner. And for this reason, we urge the committee to issue a favorable report. Thank you.
Thank you, Mr. Zavin. We'll go next to John Gossert. Go ahead, Mr. Gossert. Sorry. You have to, Mr. Gossert, you have to unmute.
Judge Gossert, can you unmute yourself? They can't hear you. Judge Gossert, you need to unmute.
There I go. Okay, thank you.
Okay, can you introduce yourself again? Okay, sorry.
Senators, thank you so much for the opportunity to testify before you today. My name is John F. Gossert Jr. I am a retired United States immigration judge. I served in that capacity for 31 years in Baltimore, Maryland. I'm not going to speak to you about the specifics of this proposed amended legislation and or the benefits. That has already been addressed. But rather, I would like to share with you a case I presided over. a gentleman by the name of Darrell. Darrell was a lawful permanent resident of the United States, a green card holder. He was married to a United States citizen and has 2 United States citizen children. He was a productive member of our society, of the United States and the state of Maryland. He was gainfully employed. He made a mistake. He was charged with a minor offense in Maryland. And being a first-time offender, he was given the opportunity to receive probation before judgment. In fact, he did. He and his wife left court, and they were happy that this experience was going to be resolved favorably for Darrell, that he would not have a conviction, that he would learn from his mistake and move forward. Darrell did not go home, however. He walked into federal immigration custody. He was subject to mandatory detention, where he remained and where he was put in removal deportation proceedings and brought before the court. He was, in fact, deported. He was banished for life from the United States. There was no remedy or relief under the law that he could apply for and or receive. His family was in shock. After his deportation, his wife, Michelle, wrote me a letter. And in that letter, she said, Judge Gossert, you have great authority and great power. Why did you not give Darrell a second chance? But I could, of course, not. In her letter, she told me that I had ruined her life, that I had ruined the life of her children. And she concluded in that letter, may God forgive you because I cannot. This I submit to you was unjust, was not fair, was not in fact humane. But under the current Maryland statute, although not a conviction, it is a conviction under the federal statute. As has been mentioned, Virginia and New York have similar probation before judgment statutes that do not in fact result in a federal conviction, that do not result in the removal and deportation of an individual. I have had to preside over hundreds of these types of cases during my career as a United States immigration judge. And it was always painful to me that those individuals who received the benefit of probation before judgment were learning from their mistake, were doomed to be banished from the United States, and in many instances, destroying families and family unity. I strongly urge the Senate to approve this bill, to do the right thing, the fair thing, the just thing. And I thank you for your time and your attention.
Thank you very much, Judge Gossert. We'll now move on to Emily Beckman. Favorable. Thank you.
Good afternoon, Senators. My name is Emily Beckman, and I'm testifying in support of a favorable report for Senate Bill 527. I'm a resident of Montgomery County and have been a practicing criminal defense lawyer for almost 15 years, during which time I've worked as a public defender in Alexandria, Virginia, as a public defender in Montgomery County, and as a defense lawyer in private practice. In my time as a public defender and private criminal defense lawyer, I've represented hundreds, if not thousands, of non-US citizen clients. Non-citizen clients are often denied the benefits of alternative dispositions like the PBJ, not because of any opposition on the part of the prosecutor or any victim in the case, but because federal immigration law considers a successfully completed Maryland PBJ to be a conviction, even though Maryland law does not. In Virginia, however, the PBJ equivalent is available to non-citizen clients so that when they successfully complete the program, they do not have a conviction under either state law or federal immigration law. This is because in Virginia, non-citizens can participate in these diversion programs after a judge makes a finding of facts sufficient to support a conviction rather than a finding of guilt. The fact sufficient finding functions really just like the Maryland PBJ does, but without being considered a conviction under federal law. Right now, defendants all over Northern Virginia are pleading not guilty, waiving objections to a statement of facts being read in lieu of a trial, and agreeing not to present any additional evidence before the court as a way of acquiescing to a finding of facts sufficient and to participation in a diversionary program. If the defendant in Virginia successfully completes all of the requirements imposed by the judge, then the charges are dismissed. If the defendant doesn't complete the requirements imposed by the judge, the conviction is imposed with no further trial or evidence required. Though the change sought through this bill may seem like a meaningless technicality, for legal immigrants charged with minor offenses like theft under $1,000 or simple possession of a controlled substance, it can mean the difference between remaining in this country and being deported. The fact-sufficient alternative provides a necessary avenue for a non-adversarial resolution of cases against non-citizen defendants so that they may receive the same benefits of a PBJ that currently exists for US citizens. It also promotes finality of judgments by reducing post-conviction litigation on behalf of criminal defendants who are not properly advised that their PBJ dispositions will be considered convictions under federal immigration law and can lead to their deportation. This bill also, am I at time?
Yeah. You are. If you could just quickly wrap up. Thank you.
Thank you. I have a couple other points in my written testimony, but urge a favorable report. Thank you.
Thank you very much, Ms. Beckman. Okay, we will move on now to favorable with amendments. Joseph Moravec. Go ahead.
Good afternoon, and thank you, members of the Judicial Proceedings Committee. My name is Joseph Moravec. I'm an immigration attorney with Fern in Columbia. But before moving to Maryland about 6 or 8 months ago, I did practice immigration law in New York, and I focused on representing state and federal detainees. And so I have similar experience working with New York's criminal procedure law, and so I hope to offer that dual perspective as others have on the Virginia side. New York's adjournment and contemplation of dismissal, or ACD provision, functions slightly differently than Maryland's probation before judgment. But the effect we hope would be adopted through HB 354 is the same. In many cases, the legislature concludes that a given offense should carry minimal punishment, but Marylanders who agree to a PBJ are still considered convicted under federal law. But in New York, the ACD provision avoids the situation by deferring and then dismissing a case after 6 months if certain agreed conditions are met. That would be similar to the provision before the committee now. By allowing Maryland prosecutors the discretion to agree to probation before judgment where justice is not served through a conviction, HB 354 would provide an avenue more appropriately balancing the consequences of an offense with the punishment intended by the legislature. I can give the court the panel an example. I represented a non-citizen in immigration court who was convicted of driving without a license. Someone ran a red light and hit him on his way to work. He was the victim, but he was still charged with and convicted of driving without a license. Sorry. Am I out of time? He spent more than 6 months in immigration detention, and the biggest barrier to his release was his prior conviction. HB 354 would bring PBJ in line with the legislature's original intent that detained citizens, non-citizens like my client, wouldn't have received a conviction, but would simply ensure that the law extends to apply to all Marylanders regardless of citizenship or immigration status. And so I hope the legislature takes the opportunity to correct the inequity, and I'm happy to answer any questions you may have about the New York provisions.
Thank you very much. Thank you. We'll move to the opponents now. Steve Kroll, go ahead.
Thank you. Good afternoon, everyone. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association, and I've been prosecuting cases since 1984. Just as a bit of a background, in this matter, last year, the Attorney General's office weighed in and had a problem with the due process elements of this bill. This bill has since been amended, and we are waiting for the Attorney General to give an official report from the opinion section before we can say whether we are for it or not for it, depending on that opinion. So at this point in time, we're opposed to the bill till we hear from the judiciary and we hear from the opinion section. And for those reasons, we're opposed to Senate Bill 527 until we get that further information. Thank you very much.
Thank you, Mr. Kroll. Move to Joseph Riley. Go ahead.
Thank you, Senator Hettleman, distinguished members of the judicial proceedings. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the legislative chair for the Maryland States Attorneys Association. We are unfavorable in this bill as it is currently now. As Mr. Kroll, the state's attorneys coordinator, stated, our opposition is mainly because we have read opinions from the Attorney General and from the judiciary that this bill would take us back into an unworkable pre-1975 probation before verdict type of disposition. As my colleagues who are proponents of this bill have noted, that there are dispositions that will not work and will be classified as a conviction. However, I can tell you something that my office has recently done. We've developed a policy where we will take certain crimes, for example, malicious destruction of property under 1,000, theft, misdemeanor theft, first offense of CDS possession, and place those matters on the STET or inactive docket with conditions to that STET. Pay restitution, stay away from the property, complete drug treatment. And after the completion of those events and after a certain period of time, 6 months to a year, bring the case back and we'll dismiss it. That's an agreement between the state and the defendant. And we believe that this will cure this ill that the proponents of this bill has. So if this bill doesn't pass, I just want the members of this committee to know that we are committed to keeping families here together legally. And we want people who are here legally to be able to stay here legally. And we are actively working on solutions to address this problem. Thank you.
Thank you very much, Mr. Riley. All right, that concludes the witnesses. Are there any questions from the members of the committee? No questions. All right, that concludes the hearing for Senate Bill 527. Thank you, Senator Lee. And you are up again for Senate Bill 623.
Okay, thank you, Madam Chair. I really appreciate it. I'd just like to get through this because on my next bill, one of the witnesses has to leave early for a trial. And but let me get through 623. This bill was before us last year, but because it never got a vote because of COVID-19, we had to end the session early, but it did have a hearing. This bill mitigates the growing threat of cybercrime in Maryland by defining the crime of ransomware and applying that crime to the unlawful possession of ransomware software with the intent to deploy the technology for malicious purposes. Ransomware is a software or program that prevents victims from accessing computer systems or records until the victim makes a payment to the perpetrator, usually involving untraceable Bitcoin transactions. Maryland state and local government agencies, as you have seen in the news, have fallen victim to high-profile ransomware attacks in the recent years. In May of 2019, you remember the Baltimore City employees were unable to access online accounts and city payment systems, and they were down for several weeks, resulting in some $18 million in restoration and repair costs for the city. These attacks are not only costly, but they also threaten our public safety. In 2018, separate ransomware attack rendered Baltimore City's computer-assisted 911 dispatcher system inoperable for almost a full day. And you also remember years ago, the attack against the Salisbury Police Department that rendered their data inoperable too. It's not just big city governments that are targeted with ransomware. Local police departments, as I mentioned before, public and private education institutions, hospitals, and other very critical infrastructure face attacks on a daily basis across our state. And some public institutions are targeted not only because they will pay the ransom so that the attack itself will generate, the attack unfortunately generates interest in the software. If an attack garners enough media attention, the software can be marketed and sold on the dark web, either as a contract hire or a transfer of the ransomware program itself. Private institutions are much likely to pay to avoid the embarrassment of having been a victim of this attack, but public institutions fortunately have more transparency requirements and make the damage more severe as they have a greater disincentive to pay the extortionists. No business, organization, or industry, no matter what its size is safe from ransomware attacks today. And it doesn't take a very sophisticated crime syndicate to perpetrate an attack. Any individual connected to the internet has the power to access and utilize crippling ransomware. As the software is disseminated more widely, opportunists like disgruntled employees will deploy these weapons with greater frequency. And I think we need to stop this and sniff this supply growth by fighting the demand. Let's be clear. Ransomware is a weapon. The software is like a loaded gun with no possible defensible purpose. We shouldn't have to wait till someone pulls the trigger to take decisive action. Law enforcement should be empowered to act against individuals and organizations who possess such weapons without a legitimate purpose before they're unleashed to wreak havoc on our schools, our hospitals, our police departments, and businesses. This is exactly what the bill does. And under SB 623, persons who possess ransomware with that intent to use it, anything other than a lawful purpose, are guilty of a misdemeanor offense and could face penalties up to 3 years, down from last year's bill, 10 years, and or a maximum $10,000 up to $10,000 maximum fine. Additional tweaks to the penalties reflect feedback we received from our wonderful chair last session, and I believe it is well balanced now. In addition to the change of the penalty for possession of ransomware with the intent to use it, I brought back some provisions from the previous versions of this bill, which include a private cause of action, which is restored, and putting in local school systems as well as hospitals into the critical infrastructure category that we have in current law, dealing with attacks against computer networks. After the attack on Baltimore County schools, this seems very reasonable, especially in the age of COVID and remote learning. Going forward, systems for schools are going to be that much more important to protect now. Iterations of this bill have been introduced in prior sessions with the support of the Maryland Cybersecurity Council, which I serve, and this version continues to enjoy the support of our council. In the past years, this legislation has failed to move forward due to minor technical concerns expressed by our former chairman of this committee. SB 623 has been adjusted to confront those concerns in order to create the best conditions for passage, because I think we need to act now. While we have a lot more work to do as a committee and as a legislature and the state to address ransomware attacks and cybercrime, this bill is a step in the right direction towards strengthening our cybercrime deterrence. Prosecutors and investigators who discover ransomware and the intent to use it should not be prohibited from preventing a harmful crime from occurring. There's no lawful purpose to have ransomware unless you are doing research, and we should not allow individuals to trade these weapons online until we create weapons of mass destruction without a deterrent structure. The private sector should also be more transparent about their attacks, and they should expect future legislation to prevent their payment of ransoms to support organized criminal entities or opportunists. However, SB 623, we believe is a first step towards preventing access to dangerous weapons that have already been targeted against our democratic institutions and the services government provides to our citizens and residents. Most of these services now contain a digital component that can be compromised far too easily with this technology. So for these reasons, I respectfully ask my colleagues to vote favorably on SB 623. And I have a panel of experts that would like to offer their testimony and expertise. Thank you, Madam Chair.
Thank you very much, Senator Lee. It's particularly prescient for the three of us from Baltimore County who are serve on this and have experienced the ransomware attack in our public school system recently. So Dr. Anton Dobora is your primary
Thank you.
witness. Go ahead.
Yes, thank you, members of the committee, for the opportunity to testify today. I support Senate Bill 623 that addresses the possession and use of ransomware. to disrupt the use of computing resources by unauthorized encryption and or locking of files and other resources. My name is Anton DeBora. I'm the Executive Director of the Johns Hopkins University Information Security Institute. I'm an Associate Research Scientist on the faculty of the Johns Hopkins University Department of Computer Science, and I serve as a member of the Maryland Cybersecurity Council. My institute has conducted research on the methods used in ransomware attacks and possible mitigation technologies and strategies. Unfortunately, this continues to be a frustratingly difficult problem to defend against conclusively. We all know about the devastating ransomware attack on the city of Baltimore government computer systems that was described earlier very eloquently by Senator Lee, and as well as other attacks. The fact of the matter is that the ransomware problem is far more catastrophic in scope and scale than even what's been described. Consider the following: as of even 5 years ago, 4,000 ransomware attacks per day that are estimated or were estimated to surpass 8,000 attacks per day this year, or will. And 79% of businesses surveyed a few years ago reported at least one ransomware attack. And the average cost of a ransomware attack in 2019 was $133,000. And the average ransomware payment rose 33% in 2020 over 2019 to over $111,000. And this situation continues to worsen with no end in sight. It's pervasive, it's effective because of its economic brilliance and simplicity. It cuts out the middleman in cyber theft operations, and the technology is simple. The technology is so pervasive that turnkey ransomware packages can be purchased on the dark web, as was mentioned earlier. Some of these services have been known to even provide a 24/7 customer support line. And so it's little wonder that ransomware has seen explosive growth with no end in sight. Based on my understanding of Senate Bill 623, I believe that it will be an effective law. And just cutting ahead, most ransomware operators use different kinds of ransomware, regularly test out new variants. And it appears to me that a prosecutor armed with evidence that an operator used any ransomware can now also prosecute them for all the different ransomware they possess. Also, I should add that in the interest of protecting researchers such as those in my institute, the bill explicitly excludes research purposes from the prohibitions on possession. My testimony here is just a brief overview of the ransomware threat, and I hope that it has been helpful to the committee. To the members of the committee, thank you once again for the opportunity to give testimony here today.
Thank you very much. Now we turn to Stephen Kroll, who I don't see in the Zoom room anymore.
Yeah, there you are.
Oh, there you are. Go ahead. Sorry.
Thank you very much, Senator Hedelman. Good afternoon, members of the committee. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association, and I've been prosecuting cases since 1984. First, I want to thank Senator Lee for sponsoring this bill, and to tell Senator Hedelman and Senator Sidner and Senator West, the Kroll family home very hard about the ransomware to Baltimore County school system. So I can assure you, we understand it very well, including it also, ransomware hit our office here. So we've had it by me and by my wife. So it's really hit us very hard. I am happy to see Dr. Anton and Marcus, who you'll hear from next. But now is the time I don't have to see them anymore, because this year, this bill is ready to pass. It's gotten all the technical flaws out of it. It's really ready to go. And the problem we have is the feds will not give us cases unless we have a state law. We cannot get federal crimes that they don't want to prosecute. They will not to us because we do not have a state law, and we need a state law. The feds prepare the case. Sometimes they don't want to prosecute for whatever reason, and we are willing to do it. We can't do it because we do not have a state law. I've repeated that 3 times, and this is the state law that we need. The law allows us to prosecute if we can, and we're willing to do it. We need the tools in the toolbox. So you hear Dr. Anton, you hear Marcus, the real experts, and they're the real experts, not me. I'm just somebody who's been a victim of it, and a family member who's been a victim of it, but who wants to prosecute it. Their expertise, and they tell us this is the bill and now is the time. And for those reasons, Senate 23 should pass this year. And again, thank you, Senator Lee, for all your hard work in this.
Thank you very much, Mr. Kroll. Marcus Rauschecker is next.
Thank you very much, Madam Chair and members of the committee. Thank you for having me. My name is Marcus Rauschecker. I'm the Cybersecurity Program Director at the University of Maryland Center for Health and Homeland Security. I also teach cybercrime and some other cyber law courses at the University of Maryland School of Law. I'm also a member of the Maryland Cybersecurity Council, but my testimony is in my personal capacity today. For all the reasons that Senator Lee and Anton already mentioned, this is a bill that I think will be to great benefit to Marylanders. We know now, I think it's very clear that the scope and cost of ransomware is enormous, it's significant, and more must be done to try to stop these types of attacks from occurring in the first place. I believe that Senate Bill 623 does just that by making the mere possession of ransomware a crime. We take a proactive step towards deterring the collection and gathering of this type of malware and cyber criminals contemplating the use of this type of ransomware malware, which I think is really important. Furthermore, as Stephen Kroll said, this bill would provide another tool in the toolbox for prosecutors who would now be able to go after cyber criminals before they actually incur damage and harm to victims. So again, this is what Senate Bill 623 would provide, and I think it's important and an important tool and an important step in the right direction. Furthermore, as was highlighted by Senator Lee, the bill would also now create very clear and significant penalties for directly attacking hospitals and schools. We are all aware of the attack on Baltimore County Public Schools at the end of last year. Unfortunately, BCPS was not the only school district in the country that was attacked by ransomware. This has been a growing trend, unfortunately. We saw it happen in our neighboring Fairfax County in Virginia. We're seeing it across the country. More and more school districts are being targeted. In addition to school districts, healthcare facilities are being targeted. Hospitals are one of the primary targets of ransomware attacks. So I think it's a really important development in this version of the bill to really call out schools and healthcare facilities as there being extra penalties for going after healthcare facilities and schools. For all of these reasons, I strongly support this bill, and I'm happy to take any questions later. Thank you.
Thank you. I think that is it for the witnesses. Are there any questions from the committee? Senator West.
Here we go. Thank you, Madam Acting Chair. I'm having a hard time figuring exactly how to address you. Senator Lee, I want to commend you in the strongest possible terms for bringing this bill. This, I think, is an extremely important bill. I'm, of course, from Baltimore County, so we experienced our own ransomware attack last winter. We still don't know the extent of the damage or whether any money was paid to the people who imposed the ransomware on the school system. So one of these days we hope to find that out. But in the meantime, I wonder why the bill is as limited as it is. It only specifically covers healthcare facilities and public schools. But there are lots of other organizations which can be, and I'm sure are being hit by the possessors of this ransomware. Why would we want to let them with impunity go after other organizations, nonprofits, private schools, churches, private businesses, small businesses, individuals who have computers without including them in the bill? So
yes, well, that's a good question. Thank you for that question, Senator West. Schools and healthcare facilities, they fall under the section dealing with critical infrastructures. We decided that they needed particularly emphasis on creating a more severe penalty for those who go after critical infrastructure. Like, for instance, under current law, we have a greater penalty if someone hacks and tries to interrupt or impair the functioning of a state government, a natural gas or electric service device or system owned, operated, or controlled by the state, by a person or other public service company, or a service provided in the state by a public service company. And then this bill just adds also the healthcare facility and public schools. And this penalty is, if the aggregate loss is 10,000 or more, then those that go after these critical infrastructures are guilty of a felony punishable up to 10 years and or a maximum fine of $100,000. So
I can appreciate all that, but I certainly that's fine. But then you stop, and so any commercial business, any small business, any private school, nonprofit, I can think of all sorts of other entities in the state that are simply not covered by this. So,
well,
would there be a problem with increasing the?
I would love to cover everyone.
So would I.
This was a compromise that we reached, and
with who?
We've been
wanted to keep
with the former chair and the current chair right now. We're trying to do something, and this is a first step. Of course, we can always work with you to include others, but we thought that these particular entities are very, they suffer a lot of severity when they are attacked because they hold a lot of information, especially our public schools and our healthcare facilities, where it could mean a difference between life or death. If you bring a healthcare facility down, paralyze it, make it inoperable, you could make the difference between life or death and damage. Public schools.
No, I agree with everything you say. I agree with every.
Well, it goes under that section dealing with the critical infrastructure. That was passed by me when I was in the House of Delegates to include certain critical infrastructures like utilities, because if one of those are attacked, it could paralyze our entire state. If there's some kind of software that's put in there like ransomware to paralyze.
Again, Senator Lee, I completely agree with you. Everything in this bill ought to be in this bill. My question is there anybody who has said, oh, we don't want to go after?
Yeah, I want the experts to testify, but also, in the bill, it also bans a person from knowingly possessing that ransomware with the intent to use it for the purpose of introducing it into a computer system. Now, those individuals are guilty of a misdemeanor with punishment up to 3 years and or maximum fine of $10,000. But I'd like the experts, Marcus and Stephen, the State's Attorney's Office, but also Marcus
and Dr. Dabura too. If
can
anybody tell me, give me a good reason why this bill should not be expanded to cover ransomware attacks on other institutions as well as on private individuals?
All right, Marcus, you are unmuted, so why don't you go first?
All right, thank you very much. Yeah, I think, and Senator Lee, correct me if I'm wrong, and also Mr. Kroll, but the way I read this bill is that the addition of healthcare facilities and public schools is there to increase specific penalties for attacking these types of institutions. All the other institutions, all the other potential victims that you, Senator West, have mentioned, private sector, churches, whoever you might imagine, those are covered already under the provision of the current law, which says that any damage or any damage done to computer system, is already punishable. Any unauthorized access to computers is already punishable. So every institution that has a computer and that is attacked, that's covered. But the purpose of highlighting healthcare facilities and public schools is there to increase penalties for anyone who actually directly attacks those types of facilities. And I think those two are highlighted because we've just seen a tremendous increase and a trend in attacks targeting healthcare facilities and schools. And it's just a fact that hospitals are coming under increasing attacks, and school systems are as well. And obviously we've experienced that right here in Maryland. So that's I think the purpose of highlighting those institutions.
All right.
Thank you, Marcus. But let me ask one further question. And I think I understand where you're coming from on that. Why aren't we including punitive damages in this? If ever a crime called out for punitive damages, it would seem to be This one would. It says the court.
Senator West, I think we've tried that in the past. Okay. And this is a compromise bill. Okay. I'd love
So
to
there, so
I'd
there are
love to
people.
have punitive damages in this bill.
So there are people on the other side.
Oh, sorry, excuse me. Go ahead.
There are people who are really arguing that we shouldn't hit ransomware perpetrators with punitive damages in order to discourage them from doing it again. There are people who are making that argument. I don't understand it.
I guess you weren't here when that argument was made. But anyway, we do have under this bill, there is, I believe, there's a cause of action too. Can you let our wonderful state's attorney speak on?
Would you like to respond to that?
Stephen?
Yes, I would. Senator West, I would urge you to look at the House proceeding of the same bill over the House and see the objections the House raised. I think it will give you an update of their feeling on it. And I think you may be able to educate some of the fine House members there to your opinion. I think that would be worthwhile.
Okay, great. I will take a look at the video of it over the weekend. Thank you very much.
All right, thank you. Dr. DeBurr, you want to comment on that as well? Go ahead.
Thank you. I just wanted to add that we really need to be concerned about this. This is so easy to perpetrate. This is a global growth industry. To tell you the truth, I don't really think it's taken off to its full potential. People that are involved in higher risk crimes can really have access to this. It's really, really worrying. And so I think that what your legislative body has to be prepared for is a cat and mouse game in the future. And I recommend agility so that you're not going to be able to foresee problems. I mean, for instance, the possession problem is a little bit tricky because someone could simply order up software that's hosted in the cloud somewhere or in another country where we don't have an extradition treaty, and not literally possess the code or the bits, but still cause a lot of harm and even loss of life. So we don't know, 5 years from now, how this crime area will evolve or morph either, because the bad guys are always trying to stay one step ahead, unfortunately. But I do believe that this bill is a good starting point, and I agree that extending the scope as far as possible, there's no downside. This is not a dual use technology, by the way. There's no good that will come of this. This is, in my House testimony, I said that think of this as digital dynamite.
Yeah, that's right.
Thank you.
All right, are there any other questions on this bill? Okay, that would conclude Senate Bill 623. Thank you, Senator Lee. Senator Lee, you're up once again with Senate Bill 629.
Okay, I'll try to get moving on this. One of my witnesses has to leave early. She has a trial, Betty Feinstein, for advocate to fight domestic violence. Everybody ready? Okay, great. See all my witnesses here. SB 629 maintains Maryland as a two-party consent state, but provides an exception to allow evidence of audio recording to be presented in court under specific conditions that the crime is domestic violence related or a crime of violence. This change allows particularly vulnerable groups such as domestic violence survivors to provide evidence of their abuse. The current wiretap law is written for a very bygone era, and technology has surpassed the law's sphere of impact. In fact, it's harmful and prevents important evidence from reaching the ears of fact finders. And in many circumstances, it even prevents victims of crime from attaining any kind of justice or safety. And currently, already 38 other states, including Virginia, Delaware, as well as the District of Columbia, and military courts have a single party consent laws. Notably, the federal government has a one-party consent provision. Under those laws, there would be no need for this legislation because any individual to the conversation could record and use that evidence in court. In addition to Maryland, there are 10 other states with two-party consent, but many states provide exceptions to the rule to protect victims of crime. We want to protect victims in Maryland. That's the purpose of this bill. Our bill is similar to carve-outs in other two-party consent states where there are criminal or emergency circumstances. For instance, our neighbor to the north is also a two-party consent state, but Pennsylvania has a carve-out if a person is under a reasonable suspicion that the intercepted party is committing or about to commit or has committed a crime of violence, and there is a reason to believe the evidence of the crime of violence may be obtained from an interception. California has a larger carve-out for domestic violence that crosses into civil proceedings as well. And Washington State provides that wire communications or conversations of an emergency nature, such as reporting of a fire, medical emergency, crime, disaster, or which conveys threats of extortion, blackmail, bodily harm, or any other unlawful requests or demands, or which can occur anonymously or repeatedly or at extreme inconvenient hour, or which relate to communications by a hostage holder or a barricade person may be recorded with the consent of one party to the conversation. Both California and Washington are not only two-party consent states, but they both have constitutional amendments for privacy. This bill does not infringe on privacy. It simply clarifies an outdated law written for an archaic technology, a bygone era in response to police misconduct. The technology that every American now has access to was entirely unforeseen when the law was passed and replicated. Unique to Maryland, of course, we have built this legislation on the existing hearsay exception circumstances of Maryland's Rule 5-803B24. Mirroring this rule, this legislation would allow the admissibility of a one-party consent recordings under exceptional circumstances if it has equivalent circumstantial guarantees of trustworthiness. Then the court must separately turn to whether it is more probative than prejudicial and promotes the interests of justice. A statement may not be admitted under this exception unless the proponent of it provides notice meeting specified criteria to the adverse party. Unlike the bill I sponsored last year, this bill would merely reduce jail time associated with unlawful recording of the other party to a maximum of 90 days, misdemeanor with a 5-year, from what was last year, or what is existing on the 5-year felony. Those victims of crime could become state's evidence and get immunity for prosecution if they bring evidence of a serious crime forward. Of course, domestic violence survivors particularly benefit from this bill. Evidence of their abuse, they can be recorded and offer as evidence in proceedings against their abuser. No longer will fresh bruises or scrapes be the only means of proof. In a 24-hour period, over 500 calls were made to domestic violence hotlines in Maryland. With such staggering number of domestic violence survivors, we must give them every tool possible to allow for the prosecution of their abusers if they so choose. This bill, as submitted, was intended to apply to civil proceedings, but there is a problem with the granting of immunity in those cases. And so we want to limit this to only those civil cases that occur with the same evidence that was already admitted during a prior criminal proceeding. We are willing to work with the committee and the council to fine tune this approach, but it would be an injustice to prohibit audio evidence of a child being abused in a child custody proceeding for instance, if there was already a criminal prosecution where that specific audio capturing the abuse was admitted. In other civil proceedings where this could be helpful will have to be reviewed at a later date. For these reasons, we urge our wonderful colleagues to vote favorably on this bill, SB 629, as amended. I'd like to turn it over to my witnesses and experts on this matter. Maybe Debbie Feinstein can go first.
Excellent, thank you.
Madam Chair. Oh, Mr. Chair, I'm sorry.
No, it's all good. We look a lot alike, so it's confusing. But thank you, Senator Lee. And so as I have Ms. Feinstein as your primary witness. So Debbie, good to see you. You've got 5 minutes.
Good afternoon. Thank you, Chairman Smith, as well as members of the Judicial Proceedings Committee. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I've been a prosecutor for almost 21 years. In my division, we prosecute cases involving child abuse, sexual assault, elder abuse, and domestic violence. These crimes occur behind closed doors, most often with no witnesses. The best witness may be in someone's hand or in the room, an iPad, an iPhone, any sort of recording device. We've had numerous examples in my jurisdiction in Montgomery County where recordings have been made by someone that is being abused, a child, an adult, and those recordings have not been able to be used. The best evidence may well be that video, and is often is. And it not only benefits prosecution witnesses, but it also benefits witnesses for the defense and the defendant, his or herself as well. The state wants to be able to view all evidence, all best evidence of what may be occurring behind those closed doors. I want to share with you a couple of examples today. First points to the issue that Senator Lee was describing regarding sort of this tension between the federal law and the state law. I received a call last week from someone that represents a victim of domestic violence in a military proceeding. The military is currently investigating her allegations. And in that case, she recorded her abuser physically abusing her. However, she is afraid to bring that evidence forward in the federal case because she could be prosecuted in Maryland, in Montgomery County, actually, which is where she did the recording. She could be prosecuted for a wiretap violation. And in fact, her abuser is threatening to turn her over to the authorities if she were to turn that recording over to the feds for their prosecution. This is obviously being wielded as a sword, not a shield, and the best evidence is being precluded from being used in that prosecution of domestic violence. Another recent example that happened in my jurisdiction involved a rape. The defendant was an Uber driver who had previously been accused of sexually assaulting a young woman in his car a year before our most recent case. That case was, we were unable to prosecute that case because the victim moved out of state and was unwilling to participate in the prosecution. The jury in our new case, which also involved the same Uber driver, obviously, and a new victim, happened, shortly thereafter. On that particular night, the victim got a ride home with this Uber driver and he sexually assaulted her. At least she believed he had sexually assaulted her. She was unconscious. She was passed out from having had too much to drink. In that case, she then went back to the club where he had picked her up from, and with literally her goal was to record him, telling her what happened to her. On the recording that she took, a surreptitious recording that she took that evening, he admitted to having sex with her. He admitted to the fact that she was, quote, wasted, that she was significantly intoxicated and passed out. And he did not deny any of that in the recording. We could not use that recording at trial because it would be against the law to do so. At the trial, not only could we not use that recording, but the defendant actually testified to a very different version of what happened after the rape. He gave a very different story. He talked about things that were completely a lie and inconsistent with what he had said in the recording. We were also not able to impeach him with that prior statement that he had made on the recording. The recording was the best evidence of what happened. The jury acquitted this now two-time rapist after the trial. And I share that with you because, again, again, this rape happened with just 2 people present. That is most often the case for rape, domestic violence, sexual offenses, offenses against children. Having the tools that we now have with these recording devices that we carry on ourselves, almost all of us at this point, is something that we need as prosecutors, and frankly, also people that are accused of crimes can utilize for their benefit, so that we can avoid false accusations, and the state can review all of the best evidence. I want to also note before I conclude a couple of things. Number one, I obviously work for State's Attorney John McCarthy, and I want to convey his position is that this entire the entire wiretapping crime should be decriminalized, that we should become a one-party state. And I wanted to note that as well. That has been his position for quite some time. I'm here to testify regarding the current status of the legislation, and I understand this is the best effort and compromise to try to have this legislation moved forward this year, and to limit our ability to use these types of statements to crimes of violence. The current legislation indicates crimes of violence under the criminal article. However, we would ask that the definition of crimes of violence be extended to the definitions under the public safety article, because that is where second-degree assault or domestic violence crimes are included. I would urge a favorable report today on Senate Bill 629. Thank you for your time.
Excellent. Thank you, Ms. Feinstein. Good to see you. So I'll go down in order. Mr. Schellenberger, you're up next.
Thank you, Chairman Smith, members of the committee. So back in 1990s, a very young prosecutor with jet black hair who was extremely handsome was the head of the child abuse unit in Baltimore County. I remember vividly having a rape case, sexual assault case involving a 9 or 10-year-old girl who was alleging that her grandfather had sexually assaulted her. When I met with the family, they came in, and please all picture this, with the old plug and play cassette player, where all the kids had it from Fisher Price back then. And they came in my office and they pressed a button in which you could hear the young girl say, "Grandpa, no, Grandpa, no," and then literally hear the bed squeak. They committed a felony in my presence. I could not play that in the courtroom. And guess what? I still can't. 30 years later, my folks in domestic violence recently had a rape case in which the defendant raped the victim, and then after that, she surreptitiously recorded him, and he explained why he raped her. Go to Christmas of this year in Baltimore County. The defendant was charged with rape. Part of the rape was caught on the nanny cam, where it recorded the portion where you hear the victim say, "I can't breathe," and the defendant says, "I don't care." Guess what? We still can't play it. We are so far away. The wiretap statute was written when only the police could record. Now we all can. We're recorded constantly. It's an accepted fact in our society. Why is it we have a statute that refers to switchboards and putting things in to a thing that doesn't even exist anymore? Every one of the prosecutors that you're going to hear from, and every prosecutor in this state could give you story after story after story where we are no longer able to bring, as my colleague Ms. Feinstein said, the best evidence. Why do we have body cameras? Because it's the best evidence. And now the best evidence in most domestic cases is right here at our fingertips. We're all used to being recorded, and we say you can't. We need to come into this century. I agree with my friend, Mr. McCarthy. We should be one-party consent, but I'm not going to be greedy. Please pass Senate Bill 629. This is a great start. We really need it. We are way behind the times.
Excellent. Thank you, Mr. Schellenberger. Next, we'll move on to Seltzer. There you are.
Good afternoon, Mr. Chairman, members of the committee. My name is Yosefi Seltzer. I'm a supervising attorney at the JAG office at Fort Meade. I'm speaking today in support of Senate Bill 629. It's a pleasure to testify before you today after testifying in favor of House Bill 720, the cross-file sponsored by Delegate Moon. I'm here on behalf of my clients who are victims of domestic violence. Some are service members and others are military spouses. The current two-party consent law creates a chilling effect that intimidates victims of domestic violence from coming forward. As you're probably aware, prosecuting domestic violence is extremely difficult. The abuse often takes place in the home where there are no other witnesses. Sometimes the victims are young, disabled, elderly, or speak languages other than English. The abusers threaten and intimidate them by telling the victim, "No one will believe you." The current law also prevents judges from considering whether to admit audio recordings that could be helpful in deciding guilt or innocence. Maryland's behind the times. The federal wiretapping statute and the military rules of evidence, along with 38 states and the District of Columbia, currently have one-party consent laws. Current law also creates a conflict, as you heard, with federal and military prosecutions that take place in Maryland. Although audio recordings are admissible in federal and military courts, they still violate Maryland law and therefore force federal and military prosecutors to question whether they should put victims and witnesses in jeopardy of state prosecution. One concern that has been raised in the past is that reducing the penalty from a felony to a misdemeanor will eliminate the deterrent effect. I respectfully disagree. Individuals that have security clearances or need background checks for their jobs or professional licenses, like lawyers, for example, will certainly not want any conviction on their record, especially one characterized as a wiretapping offense. These individuals will continue to be deterred. There was a time when various forms of evidence, such as Manny and security camera footage, fingerprints, and DNA evidence were debated. If authenticated audio recordings are available, shouldn't a judge be allowed to admit and hear them when evaluating witness credibility and deciding guilt or innocence? Isn't that a more accurate process to get to the truth of what happened than deciding simply on witness testimony alone? Let's also not forget that domestic violence survivors have civil rights and civil liberties and deserve to live free from violence and fear. Saying it another way, abusers should have their safe harbor to perform abusive conduct eliminated, and domestic violence survivors should instead receive a safe harbor to present recordings of their abuse. Thank you for your attention. I welcome your questions.
Excellent. Thank you very much. And finally, we'll have Ms. David. You're up. Good to see you.
Thank you. Thank you, Mr. Chairman, Mr. Vice Chair, and members of the committee. My name is Sarah David, and I'm Deputy State Prosecutor for the Maryland Office of the State Prosecutor, here to support SB 629 with amendments. Thank you so much, Senator Lee, for sponsoring this bill to help victims of violence, particularly those who have historical challenges being believed in our justice system. I'm going to focus on the second part of the bill, which creates the exception to the exclusionary rule of the wiretap statute. The general exclusionary rules say from a Fourth Amendment violation has exceptions, such as good faith reliance on a warrant. This exclusionary rule has no exceptions. My office handles police misconduct cases and must grapple with the inadmissibility of wiretap evidence when presented with a citizen recording the police. Other states who've had this restriction have excluded evidence where a person recorded their own murder and evidence from a child recording his own sexual abuse. The language for this exception is already in Maryland law through the hearsay rule. Hearsay is an out-of-court statement which is offered for its truth, and the exceptions to this rule include statements where the circumstances make the statement more reliable, such as a statement against someone's interest or a present sense impression, very much in line with an audio recording. This language makes it so that not all recordings are admissible if they violate the wiretap law, but can be admissible if the party who's offering the evidence can show that the evidence is of a material fact in a criminal proceeding, the contents are more probative than any other evidence that the party could get, and that the interest of justice would be best served by the evidence being admitted. The evidence also has to be disclosed to the opposing party with enough time before the trial date for them to address concerns with it. This standard ensures that parties can't rely on wiretap evidence to be automatically admissible and still dissuades individuals from engaging in secret recordings, but would allow for situations that have been described by my colleagues to have this evidence considered for admission. Thank you for your consideration to SB 629, and we urge a favorable report with the amendments that would restrict this to criminal proceedings.
And thank you, Ms. David. And with that, that'll conclude the testimony for Senate Bill 629. I'll turn it over to the committee for questions. All right, seeing none, that'll end the hearing. Thank you very much, Senator Lee. Thank you to the panelists. Have a good afternoon. All right, we'll now move over to Vice Chair Wallstreicher with Senate Bill 671. You're up.
Thank you, Mr. Chairman. Give me 1 second here to make sure I'm muted on my other computer here. So thank you, Mr. Chairman. This is an important and simple bill that will help limit police-citizen interactions. As many of you know quite well, we've been discussing the issue of force and compliance. Arrests are inherently dangerous, so we should always be looking for solutions to avoid arrests altogether and eliminate opportunities for non-compliance and force. The solution is citations. In 2014, many of us worked to establish a system of citations for very minor offenses. That system was supported by civil rights organizations, public defenders, and state's attorneys. This bill clarifies and expands our citation system. It does three straightforward things. One, it clarifies that misdemeanors with a penalty of 90 days or below are chargeable by citation. Two, it expands the statute to allow for any simple possession of drugs to be charged by citation. Three, it requires our friends at MPTSC to train on the provision of citations. There are all the safeguards and exceptions necessary in this bill. If a person is a danger to public safety, needs medical attention, or is having an overdose, or has an outstanding warrant, that person can still, of course, be taken into custody. There is also a friendly amendment that would allow arrest where the person needs to be extradited to one of our neighboring sister states. The House cross-file is by the original architect of our citation system, and I can't say this more strongly. If police-citizen interactions are increasingly the problem, expanding our citation regime is the solution. I ask for a favorable report.
Excellent. Thank you, Vice Chair Wallstreicher, and thank you for bringing this to us. And as your primary witness, we have Judge Kroom. You're up next. Good to see you.
Thank you. And let me mention, there's another witness from our organization, Maryland Alliance for Justice Reform, who I think may be in the waiting room and hasn't been admitted yet. I'm hoping that he will get let in shortly.
Okay,
so again, I'm Phil Karoom. I think I was called judge, but I should be clear that my testimony today is not official testimony for the Maryland courts. It is for the nonprofit organization, Maryland Alliance for Justice Reform. This bill, SB 671, has passed the House twice before. This year, we believe that it has no opposition. In the prior years where it got stuck in JPR, once may have been due to COVID, and previously may have been opposition of bail bondsmen who would have preferred that more people spend time in our local detention centers. We think that this bill is a valuable one in that it will not only save time of police officers. It takes a small fraction of the time to issue a citation like a traffic ticket as compared to the hours that it takes to arrest, take to booking, wait for processing, and handle someone when they must be arrested. When someone is arrested and stays in custody, it also costs more for the local taxpayers to maintain that person, either in the local detention center or wherever else that person is maintained. In today's time, when we have the danger of COVID-19 infections, having an arrest also necessarily keeps a police officer and the person arrested in close proximity, typically in a small vehicle, a police cruiser, and later will keep the arrested person again in confined quarters where social distancing may not be possible in a booking center and eventually the local detention center. There are studies that show that if someone remains in a detention center for 3 or more days, they have a 40% likelihood of increased risk of future problems because they're likely to lose a job after 3 days. And loss of that income may result in more troubles leading to more criminal offenses and more arrests. So again, everything that we can do, such as by making citations more feasible, is something that benefits the taxpayers and benefits public safety. We agree with the amendment that we know State's Attorney Riley has proposed from the State's Attorneys Association. I'll let him explain it, but it is an idea that probably should have occurred before to deal with DWIs, where the state of Maryland issues traffic citations bordering another state and needs to retrieve a person who occasionally might fail to appear for trial. The last thing that I'd like to mention in my time is the training provision of this bill. When citations originally were authorized for the decriminalized tiny quantities of marijuana back in 2014, I think it was, citations were permitted for that. When that first happened, many citations were issued in the first year after it because everyone knew about it and thought about it. But in the subsequent 2 years, when the GOCAP kept track, the number of citations in all the counties in Maryland dropped, except for one county. That was Anne Arundel County, because Anne Arundel County in its police training academy had a program whereby they introduced the question of what form of charging do you use in every scenario. And they trained to have their police officers think about the possibility of using a citation if they could. In Anne Arundel County, the use of citations increased. And today, proportionally, they issue and use more citations than any other county. And it is an efficient method, permits prosecution just as well as would a formal arrest and a more lengthy charging document. A person with a citation still would arrive in the courthouse, and if it is a drug offense, they still would be subject to requirements for drug treatment and possibly incarceration. So again, we strongly urge you to support 671.
Thank you, Ms. Kroom, and sorry, my apologies for always using the title. I just out of deference and respect. So apologies that you always qualify it afterwards, but good to see you and thank you. All right, next we'll have Mr. Schellenberger. You're up next.
Thank you, Chairman Smith, Vice Chair Waldstreicher. So I don't know what you all have done to me, but I've been supporting 3 bills today and I haven't opposed anything. I think you're starting to win. So at any rate, and here I am asking that you not arrest some people, but I am in favor of Senate Bill 671. I do hope you listen to my friend Joe Riley. He brought up a special problem with some of our jurisdictions that are connected to other states, and I think we'll have to address that. But look, this is a common sense approach. We've been expanding our use of citations. Our criminal justice system has not fallen apart. And all this does is draws a sensible line instead of going statute by statute by statute. And if a new statute passes, the next year we have to add it to this. All we're saying here is, okay, misdemeanor, 90 days or less, it's in. Even if we create a new bill this year, next year, or 3 years from now, we don't have to keep coming back and changing this. And then that plugs right in to the training that Phil Karoum has been talking about, where there's good training and they can do it right out of the bat. The other thing is an expansion into the other drug offenses. We've obviously used it a lot with marijuana. I don't have a problem with the other issues, but it does have a call out for making sure that the individual who's getting the citation is going to be safe. So if there's a drug overdose, there's a carve out and we can deal with that. And also, as with everything, there's a public safety exception. I think it's a very reasonable bill, and you know it must not be too bad because I support it.
Thank you very much, Mr. Schellenberger. I don't know what's gotten into you. I don't know.
I don't know.
I should play the lottery today.
Good idea.
All right, next we'll go on to Mr. Rose. Rose here. All right, then we'll go on to Mr. Riley. Thanks for taking my call the other day, by the way.
Oh, absolutely. Anytime, Chairman Smith. Thank you, Chairman Smith, Vice Chair Waldstreicher, Senators of JPR. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the legislative chair for the Maryland States Attorneys Association. We support this Senate bill with amendment, as was mentioned. My county and several other counties border other states. As we've increased the crimes that are open to citation, what we have seen is that people who live in other states won't appear for their trial date in the district court, subsequently getting an FTA. When that person is apprehended on an open warrant in their other state, we have no way to bring them back to Maryland if they refuse extradition. We can't apply for a governor's warrant on the citation. So my amendment is simply adding citations to the types of charging documents for which the state's attorney's office can request a governor's warrant for. That's it. Just a simple amendment to include that.
Excellent. All right. I think with that, that is the last witness for your panel, Vice Chair Wallstreicher. So with that, that'll conclude the testimony for Senate Bill 671. I'll turn it over to the committee for questions. Seeing none, that'll end the hearing for Senate Bill 671. Thank you all very much. Have a good evening or afternoon. All right. We'll now go to our final bill of the day, Senator Sidnor with Senate Bill 690. Senator Sidnor, you're up.
All right. Thank you very much, Mr. Chair, and good afternoon to everybody on JPR. Senate Bill 690 is a bill that a number of you may have seen before. It was first introduced back, I believe, in 2016 when I was in the House, and really it was introduced to serve as a balance between what we were doing with the introduction of body cameras and attempting to serve the public by protecting certain members of the community's privacy. As we all have seen, body camera footage catches people at sometimes one of the most embarrassing times of their lives, and what this bill attempts to do is to balance that need for the public to know through transparency, but also the privacy rights of some people. And the bill, what it does, it puts together a list of people who may be captured on camera that we want to provide some protection to. It also, so I mean, most of, and the list is a list of victims of many sensitive crimes. So what it would do is prohibit the releasing of the video depicting many victims of domestic violence, sexual crimes, children, and as well as vulnerable adults that may have been abused, as well as people who were caught on film that may not have been arrested and the like. But what it also does is it gives powers those people who were caught in those positions that if they wanted to access the body camera footage, they would have that right. And this was important because they may have caught something. I mean, the body cameras may have caught something that you were doing that you wanted access to, and maybe you wanted to share it with somebody. So this bill does not prohibit that. Let me see, what else does it do? For those of you who may have served in the House with me back in 2016 and 2017, I never had an issue getting it out of the House. In fact, the bill would always pass overwhelmingly. The issue always came up in the House. This was a bill that I worked with MACO on, MML in the past, and a number of others back then, and we're just hoping to change minds on this committee. So with that, I would love to be able to hand it over to my panel, starting with our representative from MACO.
Excellent. Thank you very much, Senator Sidnor. Now it's a good thing you're in the Senate, so there you go. All right. We'll now switch over to your primary witness, which is Mr. Butler. Sandy, do we have Alex Butler? All right, so we'll just
Mr. Butler is not he's not logged in.
Okay, got it. We'll move on to the next one then. So then, Ms. Jordan, you're up.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in favor of Senate Bill 690. Thank you, Senator Sidner, for keeping at this. I remember very well working with you and MML and MACO to find a good balance between protecting survivors and also protecting the counties who are dealing with these requests. As Senator Sidner said, Senate Bill 690 addresses public access to records of body-worn digital recording devices. And this is really a balance to make sure that survivors of sexual assault, domestic violence, child abuse are still protected, and that their reactions at some of the worst moments of their life are not posted on social media or abused in other ways. At the same time, we also know, particularly this session, we know how important it is to look at body camera footage and have clear access to it so we can see not only the behavior of law enforcement, but also how victims are treated and the entire process. So this is something that really strove to balance those competing interests. In particular, we had a lot of discussion about the mandatory restrictions that the custodians shall deny access to this footage. And my colleague, Ms. Shapiro, is going to talk more about that. But I do think it's important to note that privacy is not protected by allowing kind of the county employees, the folks who are custodians of records to pour through this footage. That is not protecting privacy. Privacy is actually preventing people from looking at that footage unless there's good interest in it. I also want to call the committee's attention to the testimony filed by my colleague, Ms. Ruth from the Women's Law Center. And she talks about the effect right now of the release of these body camera footage, where we have a survivor of domestic violence where the abuser has gotten a hold of the body camera footage and has posted it on social media and is using it as part of the harassment of her. It is at the point now where she won't call the police because she's afraid of having more body camera footage, and that the abuser is now sending law enforcement to her door, and she will not open the door because she is afraid of this happening again. So this is a very real issue. And since my fabulous colleagues at MACO aren't here, let me also just say that it's really important to understand, if I may just finish that, Mr. Chair, thank you. It's really important to understand this is not an absolute ban. This does not protect or prevent footage from being introduced in court. It does not prevent discovery in civil cases. It does not change the civil discovery rules. And importantly, it allows access by the subjects. Both the possible defendants and the victims still get to see the footage. Now, for the abusers or alleged abusers who have protective orders or peace orders or charges or PBJs, it says that they may not copy the footage. So they can't take it away and post it on the internet, but they will still absolutely have access. So this is a very well-balanced bill. As Senator Sidner said, it's always gotten out of the House, and we're hopeful that the renewed attention to reform and to balancing the needs of law enforcement and survivors, that it will also be reported favorably in the Judicial Proceedings Committee. So MCASA urges a favorable report on Senate Bill 690.
Excellent. Thank you very much. And it looks like we have Mr. Butler back. So Mr. Butler, you're the primary witness on this panel, so you'll have 5 minutes. Mr. Butler, here you go. The floor is yours.
Thank you, Mr. Chair. Apologies, I had a little bit of technical issues there, but I will be short. I think Ms. Jordan really did a fantastic job explaining things here, and you have our written testimony. I want to thank the sponsor and the committee for your attention to this important issue. For the record, Alex Butler, Policy Associate with the Maryland Association of Counties. You have our written testimony. The bill creates a policy governing the release of body camera footage and the accessibility for the public based on a few things. And that's ensuring law enforcement officer accountability and protecting victims of abuse. This bill is a past MACO initiative and the product of a large stakeholder work group that included many organizations, several of which you're going to hear from today or already have heard from. And you have a wide variety of support letters in your packet. And as I understand it, there is an opposition. The state's PIA is generally designed for paper documents and not really configured to address the massive amount of body camera footage, especially with the rapid adoption, which MACO is generally supportive of. It's important to remember how different body camera footage is from just dash cam. We're seeing new footage in new areas, in private homes and businesses, with a greater opportunity to see victims, and the potential for abuse of that footage is high. The bill generally gives a consistent look at privacy rights and sets reasonable standards for preventing disclosure of interviews of victims of these terrible crimes, and sets an appropriate balance. So with that, Mr. Chair, I'll yield the rest of my time or stop there. Thank you very much. We urge a favorable report.
Excellent. Thank you very much. All right, next we'll go to Ms. Shapiro.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. Melanie Shapiro with the Maryland Network Against Domestic Violence. We are the State Domestic Violence Coalition. I'd like to thank Senator Sidnor for bringing this very important bill. I told him when I first saw the bill that I had, regarding a different body-worn camera bill, raised it to our network of service providers, which are over approximately 20 service providers from around the state, to discuss body-worn camera. And many issues were raised, and this was one of them. And so I had intended on doing all this work off session regarding the release of the body-worn camera footage. And this bill is actually the answer to all of the concerns that were raised by the service providers. Because it doesn't impact the constitutional rights of any individual, it allows it to be used, as Ms. Jordan said, in civil proceedings and criminal proceedings. It can be viewed by anybody. But what it does prevent is the copying, which would prevent the subsequent release of it by an individual. And it was referenced by the last panelist, but there was a commission that was created, and there was a report, the 2015 commission regarding the implementation and use of body cameras by law enforcement officers, and that was a Maryland commission. And this was their recommendation in 2015. There was also the International Association of Chiefs of Police in 2017 held a national forum on body-worn cameras and violence against women. And this was a recommendation that came from them as well. So it's widely viewed as an issue within the larger context of body-worn camera. Body-worn camera is incredibly important. It is, there's transparency, there's accountability for police officers, but once that body-worn camera footage once it's there and once it exists, we need to make sure that the proper policies are in place to control its use and release to the general public. And so for all of those reasons, we are urging a favorable report on Senate Bill 690.
Thank you, Ms. Shapiro. Good to see you. Next, we will have for your final witness, Mr. Fitzgerald. Oh, Chief, there you go.
Okay. Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. My name is John Fitzgerald. I serve as the Chief of Police for Chevy Chase Village in Montgomery County. I'm an attorney, and I've been in this work for 37 and a half years. I was a member of the work group appointed by the governor back in 2015 to establish body camera regulations. And this bill was one of our important discussion points. We did not have any authority, of course, to change the Maryland Public Information Act, but we saw the necessity to have further
when he
conversation.
gets the message from me.
So this bill, Senate Bill 690, is a smart bill that does a few things really effectively. First of all, it does protect sensitive victims, domestic violence victims, sex crimes victims, child abuse and neglect victims, the abuse and neglect of vulnerable adults from being identified and therefore re-victimized by a body camera video. That's number one. That's important. Number two, which is oftentimes not quite understood until you carefully read this bill, it protects all Marylanders, the average Marylander, and their privacy whenever they have the police come to their house and a disinterested neighbor might want to look at that body camera video for voyeuristic purposes. If it's a benign video, it's good public policy not to allow people to make those things virally embarrassing. And this bill also protects your average Marylander. Thirdly, and this is of great importance, by the way, I failed to mention, I'm here on behalf of the Maryland Chiefs and Sheriffs Associations. I'm representing them today. This bill, the third point, is it enables people that are subjects in interest of these videos to obtain a copy and to view these videos if these videos involve uses of force by police, a video related to an allegation of police misconduct, and any incident that results in a search, arrest, detention, citation issuance, injury of a person, or a death of a person. So all of those things that the public is most concerned about will not only be seen and copied by the people in interest, but by republication, the general public will be able to see these things. And the police and sheriffs are behind this. We are absolutely in favor of that type of thing. I've talked to Senator Sidnor, the sponsor of this bill. We have a couple of friendly amendments. One of them is not so important. The other one is significant. I just want to mention that there's a piece here that allows for the viewing of these videos by someone that's under investigation for sex crimes or child abuse to view this video, not copy, but view it during the investigation. And it also allows
Time.
So our suggestion is put that back where it should be for all other Marylanders and put it in the category of criminal discovery process. That is when and where that should be viewed, not during or prior to charging. So with that, I ask for a favorable report from the committee with the amendments from the chiefs and sheriffs. Thank you.
Excellent. Thank you, Chief. And with that, that'll conclude the testimony for Senate Bill 690. Turn to the committee for questions. Seeing none, that'll conclude the hearing for Senate Bill 690. Thank you, Senators.
Chair Smith, I'm
Yes.
sorry. I wrote you a note. Bill George is in queue.
Oh, hey, okay, great. Let me, my apologies. Mr. George, hey, good to see you. Let's get you in here.
Great.
Hey, my apologies.
It's all good. And thank you for the opportunity to speak. I had a laundry list of notes and important points on Senate Bill 690, and all of the proponents ahead of me have ticked pretty much all the boxes. So I won't take a ton of your time. Bill George with the Maryland Municipal League in support of Senate Bill 690, for the record. One aspect I will take a slightly different tack on is that of the records custodians for local governments in this instance. And this bill would really help kind of streamline the process for review and redaction of Public Information Act requests, which our members and their record custodians are sometimes overwhelmed with the amount of requests, not necessarily for body cam footage, but just generally. And as body camera footage becomes more and more prevalent and starts to take on a more a new way of looking at a public record, taking a camera inside a private residence or a business, the review for Public Information Act requests becomes more burdensome and onerous on our records custodians. This bill, while promoting the framework of balance that the proponents have touched on ahead of time, also provides an excellent framework that will help streamline the review and redaction process and take a little bit of the burden off of our records custodians. I know that there are many other bills out there that touch on body cameras and perhaps mandating them for all police agencies. And if that's the case, then this bill becomes even more important because there will be more instances of Public Information Act requests for body camera footage. And you've heard us come to you with issues of costs around the use of body cameras, and a lot of that is on the back end, not necessarily on the purchasing of the equipment, but on the review and redaction for Public Information Act requests as well as storage. This will really help in some of the long-term costs because body cameras, are such an integral part of accountability for the police officers themselves, but also for the citizens with whom they interact. So thank you for the opportunity, and thank you to Senator Sidnor. With that, we ask for a favorable report. Thank you.
Excellent. Thank you, Mr. George, and my apologies again. Sorry about that. And with that, that'll conclude the hearing for Senate Bill 690. Excellent. Okay, so that concludes the hearing for the day. We have, as you all know, we have one bill left in our policing and community safety package left to vote. So let's call it 3 o'clock in the committee room. Let's meet at 3 o'clock in the committee room for voting. Sound good, everyone? All right, excellent. See you all soon.